At 2.
My lord, I beg to upgrade item number 50, my lord. On the last occasion, your lordship was pleased to hear the matter at length, my lord.
Mm.
So I pray before your lordship for upgradation, my lord. That matter, my lord, 4 years after affair has been lost.
We'll take up. Don't do. In the first of itself.
First of all, sir, lordship.
May I please, my lord? Item number 40, my lord. We have been recently engaged, my lord. We
Item number?
40, my lord.
Yes, Mr.
My lord, 2 week time may be granted, my lord. Recently, we have been engaged. Let's go through the entire record.
Have you file a call number?
Yes, yes. My lord, name of senior advocate David Narjay is on also.
Mr. Hello, you are appearing or what? You are appearing?
No, Lordship, I'm not in this.
Who is appearing in the other side?
That side, my lord.
Mr. Chauhan, you will be represented by someone.
PP, my lord.
40,
I am for the appellant, my lord.
40.
40.
40, we are there, and I think there is another private respondent as well. Notice perhaps is not served. Thank you. Names are not shown.
40. Just wait for a few minutes. Yes, ma'am.
Lordship, I beg to mention item number 26 on behalf of Shahina Parveen, Lordship. She is out of station. Only Ariane.
26.
Yes, Lordship. Her name has not been shown earlier also. And her junior name is shown today, but he has already left.
Registry shall reflect this
Only-
matter. Showing the name of MS Parveen. Along with Mr. N. Burwal and Council.
And who already left, Lordship.
S. Parveen. The council for the appellant. After 2 weeks, only date to be fixed by the registry. Yes.
May I please your lordship, madam? Last Wednesday, your lordship has heard the matter item number 52, my lord. Supplementary, my lord. That matter, my lord, section 4 of the Act in respect of ACE specification, this matter has been heard on land, my lord. If possible, my lord, can be taken up at two one matter has been fixed, your lordship. Thereafter, if possible, my lord.
You have noted down. We'll see, Mr.
Yes, ma'am. Yes, ma'am. If possible, ma'am.
Yes, Mr. Halu.
Lordship, for listing of a matter, criminal revision, Lordship, we filed it on 15/7, Lordship. It was not listed as on the paper. I'm praying for listing it on 19th, Monday, Lordship. Small matter, very small matter, Lordship. Lordship, and
21st.
21st. Earlier.
May I please, your lordship? I beg to update list, my item number 48 and 49. Then 2 p.m.
Yes.
48 and 49.
You want to upgrade?
Yes, your lordship.
We'll take it at 2 o'clock.
Obliged.
May I please, your lordship indulgence to list a matter on 20, my lord.
Why?
My lord, there are some urgency. We have challenged the order of passed in the domestic violence case. There is a order for maintenance. My lord, that has been challenged.
When is the hearing day, Mr. Sharma?
21st, my lord. Obliged.
May it please your lordship, I pray for listing of a criminal petition, my lord. Lordship, this matter, my lord, the person concerned is undergoing hemodialysis, my lord. So I pray that this matter may be taken up on 30th, my lord. 30th Friday.
For 30th, you make a mention on 27th.
Lordship,
For 30th, you make a mention on 27th.
on 27th.
May I please?
Oh.
My lord, I beg to mention for listing in appeal, my lord. It is my lord conviction for 3 years, my lord, along with bail petition, which was filed, my lord, on 12th, my lord, but not listed, my lord. So, my lord, can be Monday, my lord. There is urgency, my lord, since he's in custody, my lord.
When is the judgment passed?
My lord, on 31st July.
Petitioner is outside or?
No, my lord, in custody, my lord. So, my lord, there is urgency, my lord, on 19, my lord. 3 years conviction, my lord.
We have it on 21st. Make a mention on 20.
Okay.
May I please? I beg to mention item number 2, my lord. I am on behalf of Mr. P.K. Roysodev, my lord. He has not come today because his relative has expired, my lord. That is why I have
Somebody
praying
in his
for
family
everyone.
expired.
My lord. Item number 2 and item number 44, my lord.
2 and
44.
they submitted the bar that Mr. P.K. Roy should be the council. Already, দুটা item ওটা মারি দিল। Grant of bereavement. And as such. Sort item immediately. I have been great for prayer along. List after 2 weeks only they will get from the list. Yes.
Obviously.
May it please your lordship, I beg to mention item number 16, as the engaged legal aid counsel is out of station.
Okay. 16 of same prayer for it. As wishes, regular funds. Engage regular. List after 2 weeks. Yes.
Yeah, please, my lord, I beg to mention item number 13, my lord. In this case, my lord, the respondents are yet to find a response, my lord. Lordship, with your lordship permission, can be fixed after 2 weeks, my lord.
You are waiting for? You are
I'm
waiting
waiting for
for
the petitioners, my lord.
let us see, let them
My
matter
lord.
reach.
My lord, I'm obliged.
Our objection is there. Oh, Nandita, do you have?
We are taking time to.
Oh. Thank you. Yes, the service is an error. Service.
Heard Mr. S. Sohan, learned counsel appearing for the applicants plus applicant. It is seen from the reports of the processor that the respondent number 2/informant received the copy of the notice on 31/08/2023. However, till date, the said respondent such and such has not appeared, has not entered appearance in the matter. Please conclude. In view of the above, Sarfaraz Nawaz notified amicus curiae as per the notification number 23 dated 18/04/2024 issued by the Register of this High Court be appointed as the amicus curiae for the respondent number 2 informant. Registry shall serve a copy of this memo of appeal along with the copy of the interrogatory application IA criminal 703/2023 and the objection filed by the state in said IA criminal 703/2003 on or before 21st of August. Obtaining the signature date. List this matter again on 28, reflecting the name of Mr. S. Sohan, learned counsel for the appellant. And Mr. Such and such, learned amicus curiae along with the public prosecutor for this state.
My lord, name of my senior lands in the.
Along with it.
Maybe seven, my lord.
The senior counsel with Mr. S. Sohan.
But I appear for on behalf of Senior Counsel Jet Kumar, he's out of station.
Lordship, I'm sorry, Lordship, from time and again, they are doing the same act, Lordship.
Lordship, any day.
Last
Lordship could pick-
2010, Lordship, this matter has been pending for trial, Lordship. And what is the
Lordship?
order, Lordship? It's a very simple order. He can also argue, Lordship.
No, I am not on record today only, I'll buckle out number.
Last many occasions, Lordship, on the last occasion, counsel didn't appear. Prior to that, they also, Lordship, they didn't appear, Lordship. Every day when the matter was listed, they didn't appear. And offense is very serious, Lordship. 2010, Lordship, matter is pending for trial, Lordship, without any reason, Lordship. Trial court is also not proceeding with the trial, Lordship.
Lordship, as far as I know, Lordship, this matter was tagged with another matter of PMLA. And it was segregated, and thereafter, Lordship, it has come alone on the last occasion and today. Moreover, lot of developments have taken place as per my instruction.
Mr. D. Bora, counsel appearing, granted counsel submitted that Mr. Ajit Kamal and senior counsel for the petitioner is out of station. And as such matter be adjourned. for the deed. To which Mr. M. Halil, understanding counsel CBI, objected for any such adjournment. It is seen has already been on earlier occasion, on the previous occasion. On 08/08/2024, the petitioner has remained unrepresented. And the court already observed that there is no stay order relating to special case number 6/2012 or special case number 10/2010 pending before the Court of Learned Special Judge CBI Assam Guwahati, in which the petitioner is the accused. List on 27.
Mr. Advocate, Mr. RD is on leg in court number 1 meter with
Yes,
RD, Mr. Advocate RD is in court leg in court number 1 meter with time being here.
Lordship, Passover for the time being, I have problem, Lordship. If your Lordship fix on another date, in the meantime, I can file my wakalatnama in their criminal petition also, Lordship. Your Lordship may remember that they have said that I have sold out the vehicle to third party and thereafter, Lordship, I am saying that I have surrendered the vehicle to the insurance company. My case is that, Lordship, I have deposited some post-dated checks with insurance company and they have utilized it for NI Act offense, Lordship. So against that, I am praying for quashing, Lordship. And I have filed one FIR, Lordship, in regard to that surrender and regard to vehicle, Lordship. They filed quashing of that FIR, Lordship. And in the meantime, Lordship, arbitration proceeding was initiated and award was also passed. If your Lordship permit me, I can hand over the award of the arbitration proceeding, Lordship. Oh, petition is so big. It's not my petition. Yes, petition.
Look at the record thing, I'm going to very difficult to record say.
Yeah, actually, most of the papers are the bank account statement.
Bank statement. Agreement. Like this, retail, retail.
Your Lordship, if your Lordship is taking up the matter, then your Lordship kindly see Annexure 3, page 17, Lordship.
Mr. Sri, just a minute. Take your seat. Heard. Ms. Saraswati, I'm also appearing for the petition in criminal petition number 385, public 2022. Also heard learned counsel for the petitioner in criminal petition number 1345, public 2023. The petitioner of criminal petition number 385/2022 is the respondent number 2 in criminal petition number 1345, public 2023. You are appearing?
Lordship, I'll file my wakalat laba. I have not yet filed, Lordship.
Ms. R. Sudhir, learned counsel for the petitioner in criminal petition number 385/2022 have instruction from the petitioner to appear on his behalf in criminal petition number 1345/2023. Place this matter on 29th. The respondent number 2 in criminal petition number 1345/2023 / petitioner of such and such shall file its wakalat number on or before 22nd.
Lordship,
Please put the matters in such and such. What did we say?
Lordship, instead of 29, if your Lordship fixes September 2, 3, any date, Lordship.
Okay, on third.
Lordship. Lordship. In my petition, Lordship, there is an interim.
There are interim in both the matters.
Until 5.
Petitioner before your lordship of Jimna for a mobile mallet.
Yo, Jimma.
See, on 17th of July 2024, there was a specific direction that if the concerned IO fails to place any such report, court shall consider to pass.
This is which Thana?
And also for his personal appearance.
Lordship.
Now,
Of Kaki Police Station.
thereafter, two more. That was an order passed on 17/7. Now thereafter matter was listed on 24/7. Then on 12.
In fact, I was supposed to bring it. Lordship will take it up at 2. I've already sent the information. They must have sent something. Kaki Police Station, Lordship will take it up at 2. I'll get back. Lordship.
And
Lordship, we have. The respondent has informed that they have not received a copy of the revision petition.
yes,
Lordship, we have not received the copy of the revision petition from the other side. In this case, my lord, we will supply today. Leave petition was filed, that was allowed. Now I'll send a copy.
that
Maybe
we have
taken
seen.
up- Yes, maybe taken up after 2 weeks or so.
Heard Mr. A. Ganguly, counsel appearing for the petitioner. And Mr. D. Chaudhary, right?
R.K. Sharma for D. Chaudhary.
Counsel for the sole respondent. Petitioner shall serve a copy of this criminal revision petition along with the annexes appended to Mr. Such and such during the course of the meeting. List on 28. I list after 2 weeks on a date to be fixed by the registry.
May I please, Lordship? On the other day, your Lordship directed us whether after order of the Honorable High Court, the party has approached the lower court or not. Thereafter, we have applied and we have found that we have several times we have approached and these are the certified copy. Even then, not a single money has been paid. So our prayer is this, the director of pension should be directed to deduct the granting maintenance and to deposit the same in the account of the present respondent. And court also expects the view that first you prove that we have approached before the lower court after order of the High Court, and this is the proof. Sorry.
None appeared for the petitioner. On call. The name of the council has been reflected in the court list. Mr. Amir Mahmood, Learned Counsel, has entered appearance on behalf of the sole respondent. List on 22nd.
My lord,
For
nothing
Mrs.
is paid, that is the problem.
That was, we're doing it, because we do not want to pass any such order in absence. That's why we fix it on 22nd.
But it is long pending area, long pending area.
We'll see what process can be taken, how to recover that amount. We'll do something.
So we wanted that director should be directed to pay
We'll
the,
pass that order on 22nd. Let the matter, the council be here. If you on that day also he remains absent, we'll pass the order. Yes.
We have challenged the judgment, my lord. passed by the Sessions Chief Senator, my lord. In upholding the order, judgment order dated 6/7/22 passed by the SDJ Nazira, my lord. My only point here in my lord, both the interim judgments, my lord, do not follow the law, my lord, laid down by the Honorable Supreme Court, my lord. In Rajneesh versus Neha, my lord. So, my lord, even if in interim maintenance case, my lord, the affidavits should have been, my lord, invited from both the parties. And that is not the case in both the forum below, my lord. That is why I am here before this honorable court, my lord. And in fact, I've been paying the respondent wife, my lord, 5,000 rupees out of my own. Because the law has already changed, my lord. The previous era, my lord, wherein, my lord, the inconveniences of the parties were looked into. Of course, that is still the, my lord, relevant issue, but still there is a format given, my lord. The affidavit has to be filed. No way out, my lord. My lord will get the impugned judgment at page 65.
Yes, Mr. Raman.
And another aspect, no, just quick point, my lord. My learned friend has filed an affidavit in opposition. And at para 11, lord, they tried to distinguish the judgment passed by Honorable Supreme Court. They say that that judgment, my lord, was the requirement regarding the requirement of affidavit of disclosure of assets and liabilities only limited to the pendency of the case. But my submission is, lord, that judgment was passed on 2020. And this impugned judgment of the SDJ Nazira, my lord, was passed in 2022. And also the Sessions Court judgment, my lord, in 23. So they have my lord, really misplaced the judgment, my lord. Perhaps it's for inquiry.
My lord, I have filed an affidavit, like my learned friend has said.
When did you file?
My lord,
When did you file that affidavit?
my affidavit, my lord, this is dated 28 9/23, my lord.
How come it is
My lord, I would like to take your lordship through page number 109 of my affidavit, my lord. Page 109. Which is the
Yes.
finding of the learned trial court, my lord. May I
Yes.
read, my lord? The first para, however, the opposite party has not adduced any evidence to show his income as stated in the WS. During the evidence, the opposite party has deposed that they runs a school and he rents out his vehicle. The opposite party has further deposed that he looks after the tea garden of his father. And being in a joint family, all the income goes in the name of his father. Thus, from the evidence DW, though the monthly income of the opposite party cannot be ascertained, but it is become clear that he belongs to a well-to-do family, my lord. My lord, this is the finding of the learned, SDCM, learned trial court below, which has been, my lord, affirmed by the learned session judge also, my lord. My lord, I would like to take your lordship pro page number 119, my lord. Paragraph 17, my lord. And I read, my lord, from the testimony of DW1, that is the opposite party, Jabir Hussain, it is evident that he has admitted the fact that the petitioner, Benjir Narfa Azam, is at present staying with the parents and not with him. As admitted fact need not to be proved at all. As such, it is evident that both the parties are living separately with each other, and as such, the OP Muhammad Jabir Hussain is responsible to pay the maintenance allowance to her and her minor daughter. From the impugned order of the learned lower court, it is seen that the learned court below clearly discussed those points and has rightly passed the interim maintenance order directing the OP Muhammad Jabir Hussain to pay rupees 4,000 to the petitioner, Benjir Narfa Azam, and 3,000 to her minor daughter as monthly maintenance allowance, considering that the petitioner Benjir Narfa Azam was married by her husband OP Muhammad Jabir Hussain socially and out of their wedlock. One female child was born, and also considering the present status of the price index, since the petitioner Benjir Narfa Azam had no income of her own, whereas Muhammad Jabir Hussain has sufficient income, who is a well-established businessman and being an able-bodied person, he is quite capable to give maintenance allowance to the petitioner and his minor daughter, and hence, considering all aspects, learned trial court has rightly passed the interim maintenance allowance, which is is quite reasonable. Regarding the income of the petitioner Benjir Narfa Azam, it is stated that in the petition as well as in the evidence in Miss case number so and so that she has no income of her own of her own. On the other hand, Muhammad Jabir Hussain had his own income of his landed property and business, and in spite of that, he neglected to provide maintenance without any reasonable ground. So, my lord, both the learned trial court has come to a conclusion that he has reasonable income, my lord, and he belongs to a very well-to-do family. Tea gardens, schools, vehicles to rent out. Now, my lord, I would like to take your lordship through the next annexure, my lord, page number 122, my lord. Page number 122 of my affidavit. The opposite party is present and has deposited rupees 5,000. Let the amount be paid to the first party, seen the petition number so and so, filed with the petitioner, by which she has prayed to issue distress warrant against the opposite party, as the opposite party has not paid the maintenance amount to the first party petitioner, amount in the area of 97,000 rupees. Now, my lord, next annexure, 123 page number. Here, my lord, a distress warrant was issued to him. Now, my lord, now the outstanding amount is more than 1 lakh. And
Is he paying regularly?
he's not paying, he's paying an amount, but there is an outstanding amount, my lord, more than 1 lakh. And the amount is per month is 7,000, which is very less. There is a daughter also, my lord.
My lord, whatever my learned friend has submitted, my lord, based on the judgments, impugned judgments, if the judgments were par inquiry, my lord, how can those be, my lord, binding to me, my lord? And in any case, my lord, these facts, my lord, that he has thus now read out, my lord, this seems to be put into perspective, my lord. You should have affidavit as my lord laid down by the Honorable Supreme Court. There has been a detailed format, my lord. Kindly see the judgment, my lord, there is a detailed format. All these things have to be put by both the parties, my lord. Not like this, my lord. This is the method of bygone era, my lord. Now there is no more in existence, my lord.
And let's ask from the judgment. of
Yes, my
reference.
lord. Kindly see.
We have the judgment before us.
All right.
Show us from the judgment.
Yes, I also.
We have, Nalage, we have the.
Yes. Sir. First, I would like to take my lord, to yes, my lord. Enclosure 1, my lord.
Read para 31 of the judgment.
Yes. 31, my lord. Yes. Section 22 provides for maintenance of dependents. Section 23 provides that while awarding maintenance, the court shall have due regard to the criteria mentioned therein. Number 23, amount of maintenance. It shall be in the discretion of the court to determine whether any of this, what maintenance shall be awarded under the provisions of this act. And in doing so, the court shall have due regard to the considerations set out in section 2, subsection 2 of subsection 3, as the case may be, so far as the applicable. In determining the amount of maintenance, if any, to be awarded to the wife, children, or aged infirm parents under this act, regard shall be had to the position status of the parties. No, Lord, this is in regard to Lord, section 23, my lord.
Come to next para.
Yes, my lord. Para 32, my lord. Chapter 9 of the CRPC 1973 provides for maintenance of wife, children, and parents in a summary proceeding. Maintenance under section 125 CRPC may be claimed by a person irrespective of the religious community to which they belong. The purpose and object of section 125 CRPC is to provide immediate relief to an applicant. An application under section 125 CRPC is predicated on two conditions. Predicated into condition, the husband has sufficient means and neglects to maintain his wife, who is unable to maintain herself. In such case, the husband may be directed by the magistrate to pay such monthly sum to the wife as deemed fit. Maintenance is awarded on the basis of the financial capacity of the husband and the other relevant factors. So this is my lord, so far as section 125 CRPC is concerned, my lord. Now, my lord, learned Supreme Court's observation, my lord, may I take my lord to page.
Matter relates to 125 only.
That is 125, my lord. Now, my lord, regarding all maintenance proceedings, the Honorable Supreme Court has hailed, my lord. Kindly see, my lord, at page 367.
The last paragraph.
Paragraph, my lord, 62, my lord. Now, my lord, may I read, my lord? Payment of interim maintenance. The proviso of section 24 Hindu Marriage Act inserted so and so, and the third proviso of section 125 CRPC in so and so provides that the proceeding for interim maintenance shall, as far as possible, be disposed of within 60 days from the date of service of notice on the contesting spouse. Despite the statutory provisions granting a time-bound period for disposal proceedings for interim maintenance, we find that applications remain pending for several years in most of the cases. The delays are caused by various factors such as tremendous docket pressure on the family courts, respective adjournments sought by parties, enormous time taken for completion of pleadings at the interim stage itself, etc. Pendency of applications for maintenance at the interim stage for several years defeats the very objectable issue. Now, next paragraph. At present, the issue of interim maintenance is decided on the basis of pleadings, where some amount of guesswork, this is important, my lord, where some amount of guesswork or rough estimation takes place, so as to make a prima facie
That's
assessment.
related to interim maintenance.
That's interim, yes.
We are not on interim maintenance now.
Yes, my lord, it applies to interim maintenance also, my lord, so far as the affidavit is concerned, my lord. That is why I wanted to show, my lord. At para now, my lord, 72, my lord, page 369. Keeping in mind the need for an uniform format of affidavit of disclosure of assets and liabilities to be filed in maintenance proceedings, this court considers it necessary to frame guidelines in exercise of our powers under Article 136, read with Article 142 of the Constitution of India. Next, the affidavit of disclosure of assets and liabilities annexed at enclosure 1, 2, and 3 of this judgment, as may be applicable, shall be filed by the parties in all maintenance proceedings, my lord, including pending proceedings before the family courts, district courts, magistrates courts concerned, as the case may be throughout the country. Next, my lord, the applicant making the claim for maintenance will be required to file a concise application accompanied with the affidavits of disclosure of assets. Next, my lord, the respondent must submit their reply along with the affidavit of disclosure within a maximum period of 4 weeks. The courts may not grant more than 2 opportunities for submission of the affidavit of disclosure of assets and liabilities to the respondent. If the respondent delays in filing the reply with the affidavit and seeks more than 2 adjournments for this purpose, the court may consider exercising the power to strike off the defense of the respondent. If the conduct is found to be willful and contumacious in delaying the proceedings. On the failure to file the affidavit within the prescribed time, the family court may proceed to decide the application for maintenance on the basis of the affidavit filed by the applicant and the pleadings on record. So, my lord, this is the position.
Well, this is very clear, my lord. There is a sufficient means to provide maintenance. The husband has sufficient means.
That is
Very-
absolutely okay, my
very
lord, but
clear
that has to
from
be put into affidavit, my lord.
Very clear, my lord.
Because I have
Both
the right to reply, my lord. What they claim, I have to file to reply, my lord.
Both the court below, my lord, have decided on it, that he has sufficient means. Now, this is not a guesswork. 7,000 is not a guesswork, my lord. When a person has a tea garden, as a vehicle, as school, the minimum
my lord-
maintenance have been paid, my lord. What is the repercussion, my lord? The wife doesn't have any income. Would she suffer from vagrancy? So because of this technicalities, my lord, which is also largely because, with regard to the pending cases. Now, in both the lower court below, the case has been disposed of. It's before your lordship now. And look at the conduct, my lord. There are 97,000 area, my lord. He's not paying regularly.
And my lord, also, my lord, page, para 127 is also important, my lord. The final directions, my lord. 127, my lord. Unless and until but this method is not followed, my lord, the all order, my lord, is per inquiry, my lord.
What are the final directions?
Yes, may I read, my lord? In view of the foregoing discussions as contained in part B to 1.5 of this article, we deem it appropriate to pass the following directions in exercise of our powers under Article 142 of the Constitution of India. This is the law. Issue of overlapping jurisdiction. To overcome the issue of overlapping jurisdiction and avoid conflicting orders being passed in different proceedings, it has become necessary to issue directions in this regard so that there is uniformity in the practice followed by the family court, district court, magistrate courts throughout the country. We direct that where successive claims for maintenance are made by a party under different statutes, the court would consider an adjustment or set-off of an amount awarded in the previous proceedings while determining whether any further amount is to be awarded in the subsequent proceeding. It is made mandatory for the applicant to dispose the previous proceedings and the orders passed therein in the subsequent proceeding. If the order passed in the previous proceedings requires any modification or variation, it would be required to be done in the same proceeding. Payment of interim maintenance. The affidavit of disclosure of assets and liabilities annexed as annexed enclosure 1, 2, and 3 of the judgment, as may be applicable, shall be filed by both parties in all maintenance proceedings, including pending proceedings before the family court, district court, magistrate court concerned, as the case may be. Criteria for determining the quantum of maintenance. For determining the quantum of maintenance payable to an applicant, the court shall take into account criteria enumerated in Part B3 of the judgment. The aforesaid factors are however not exhaustive and the court concerned may exercise its discretion to consider any other factors which may be necessary or of relevance in facts and circumstances of the case. Date from which maintenance should be awarded. We make it clear that maintenance in all cases will be awarded from the date of filing the application for maintenance as held in Part B4 above. Enforcement of execution of orders of maintenance. For enforcement of execution of orders of maintenance, it is directed that an order or decree maintained by of maintenance may be enforced under Section 28A of the Enumerated Expenditure, Section 26 of the DB Act, and Section 128 of the CRPC as may be applicable. The order of maintenance may be enforced as a money decree of a civil court as per provisions of CPC. More particularly, Section 51, 55, 58, 60, read with Order 21. Before we part with this judgment, we note our appreciation of the valuable assistance, Mother.
Please take your seats.
Yes, ma'am.
Yes, Mr. Raman,
My lord.
the
My lord,
judgment was delivered on the Honorable Apex Court judgment on 4th of November 2020.
yes, my lord.
And then it was observed by the Honorable Apex Court at paragraph, which says judgment.
Sir, I'd like to read 2, 3 paragraphs from the judgment.
Yeah, sure.
I have this Manupatra copy, my lord. For me, it's 31. In Bhagwan Das versus Kamla Devi,
No, ultimately, all those matters are considered.
considered.
After considering all those matters,
My lord,
the
but
Honorable
what is
Supreme
the
Court has come
purpose
to
of
the finding.
125, my lord?
Right.
I suffer from vagrancy, from destitution, my lord. Now what will happen, my lord? Already look at the conduct of the petitioner, my lord. There was a distress warrant being issued.
That is different.
And
We'll
both
come
the
to
trial
it.
court below, my lord, they have come to a conclusion that he has
That we
sufficient
have
means,
seen.
my lord.
Mr.
So for
Raman.
mere technicalities, my lord, I
No,
should
this
not
is
be allowed
482
to suffer from
application, my lord.
vagrancy, my lord.
We have approached this honorable court under 482 bill.
My lord, I should not suffer from vagrancy and destitution because of mere technicalities, my lord. Both the learned trial court below, my lord, I have read from the judgments, my lord. It has made very clear that the petitioner has sufficient means to the extent of tea garden, vehicles, schools, and what I have been provided 7,000 for 2 people, my lord. Now, I'm just requesting your lordship that what would be the repercussion, my lord? Should I suffer from vagrancy? What will happen to this daughter, my lord? And that thing has been discussed in the judgment. And the consequence cannot defeat the purpose of the section, my lord, 125. Maybe posted for hearing, my lord. In the meantime, I may be allowed, I may be paid this 97,000. Now it is more, my lord. Your lordship may decide that in the hearing stage, my lord. But as of now, there is a outstanding amount, I may be paid that.
My lord, Mr. Holden. My lord, if that argument, my lord, my learned friend is to be taken, it may be ridiculous, my lord, because those orders, my lord, did not follow the law, my lord. And how come an outcome of those orders can be, my lord, enforced, my lord? That is why, my lord will decide it, my lord, as per the relevant law, my lord. But the argument my learned friend is putting forward, my lord, is absolutely have no relevance, my lord. Because when law is not followed, then how come the outcome be will followed, my lord?
But we need to go to the object of it.
And
What was the
being a 482 application, I am not even gone to the facts, my lord, that I had put in my petition. Because there is not, I think, my lord, this is not required to, my lord, because there is a point of law to be decided, my lord. I can also argue regarding the facts, my lord, if my lord permits. my lord, what I may submit, my lord, there are two probable, my lord, situations may arise, my lord. One, my lord can decide it, my lord, and directing both the parties to, my lord, file the affidavits. Or my lord may, my lord, set aside the orders impugned, my lord, and send it for fresh consideration in accordance with the law, my lord. That is these are the two situations that I conceive, my lord.
Without paying anything to your.
No, I'm paying, my lord, 5,000 I'm paying.
Show us that you are paying regularly.
My lord will give me some time, my lord.
No time, Mr. Once you are arguing, Mr. Chakraborty, don't say that. Show us that you are paying regularly 5,000.
No, no, I have I can get the receipts, my lord. My lord
Tell
will
us
give
on
me,
when, since the date of the order, how much you are paying regularly.
yes, I can put it, my lord, on record. My lord will give me 1 hour time, my lord. I will do it, my lord. Or
And what about the area amount?
area, my lord, say, my lord, that is why, my lord, I am before this lordship, my lord, because those orders.
You are saying 5,000 rupees.
Yes, 5,000 I am paying.
Okay, instead of 7,000, 5,000 you are paying.
Yes, ma'am.
And show us that you have also.
Give me
area amount
1 hour
that
time,
you
my
have
lord.
paid.
Give me 1 hour time, my lord. I will put it on record.
Okay. Get back to us at 12:30.
All right.
Obliged.
May I please, your lordship? My lord, the last order passed by your lordship reflect that your lordship has already dealt with the matter. The issue is here, my lord, amendment. May I proceed, ma'am?
Yes.
The application for amendment was filed before the trial court. That was allowed. Application for amendment in the body of the complaint, as well as application for amendment of the chief, evidence in chief. Allowed. I approached the session judge. Session judge dismissed my petition with a cost. Surprisingly, much. Therefore, I am before your lordship. Initially, this honorable court, after my lord initial hearing at the motion stage, was pleased to stay the proceeding. Here only the legal issue, and nothing more, man. Whether a criminal court is empowered or law permits allowing somebody, the complainant or the informant, to make amendment in the complaint as well as in the evidence. This is the law. And I am relying upon only two decisions. I will not bother your lordship, my lord, with series of judgment. Only two decisions. Here, the court is very much, Supreme Court, clear that there is no provision in the CRPC as regards amendment of pleadings. However, typographical error on the cost title, that can be allowed. In one case, it is held. And in the another case, it is held that at subsequent stage, no amendment at any cost can be allowed. These are the two judgments I am relying on. The two judgments I am relying upon, one of these two judgments, the session judge has relied upon, but session judge has construed, my lord, wrong, has interpreted wrongly this judgment. So may I please your lord, place before your lordship the judgment I am relying upon.
Just a minute. Just take your seat. Yes, please.
So here, this is only the legal issue that I am, my lord.
Yes, the judgments, please.
Yes, my lord. These two judgment, it is yes. First one, my lord, S.R. Kumar. S.R. Kumar versus S. Sunan Raghuram. Here I am relying first is paragraph 3. There are some factual metrics. The respondent filed the complaint on such and such, and his statement was recorded in part on such and such, and further recorded on such and such. Next day, that is on such and such, the respondent move an application seeking amendment to the complaint by praying for insertion of para 11A and 11B in the complaint, stating the fact of poem named such and such written by the appellant in connivance with his mother, A2. Depicting the respondent as villain, Khalnayak, with an intention to malign the character, image, and status of the respondent. So this is the fact. After recording of statement by the magistrate under 202, this application was moved for amendment. Now your lordship turn to paragraph 18. In so far as merit of the contention regarding allowing the amendment application, paragraph 18. I'm sorry.
Yes.
Is concerned, it is true that there is no specific provision in the court to amend either a complaint or a petition filed under the provision of the code, that is CRPC. But the code have held that the petition seeking such an amendment to correct curable infirmities can be allowed even in respect of complaint. My lord, kindly note this, even in respect of complaints. But here, complaint as well as evidence. In such and such versus such and such, wherein the name of the company was wrongly mentioned in the complaint, that is, instead of such and such, the name of the company was mentioned as such and such, to be amended. In such factual background, this court held as follows. So, name of the company in the cost title, there was a typographical mistake. That was allowed. Paragraph 19. What is discernible from such and such is that an easily curable legal infirmity could be cured by means of a formal application for amendment if the amendment sought to be made relates to a simple infirmity which is curable by means of a formal amendment, and by allowing such amendment, no prejudice, that is important matter, no prejudice could be caused to the other side, notwithstanding the fact that there is no enabling provision of the code for entertaining such amendment. The code may permit such an amendment to be made. On the contrary, if the amendment sought to be made in the complaint does not relate either to a curable infirmity, or the same cannot be corrected by a formal amendment, or if there is a likelihood of prejudice to the other side, then the court shall not allow such amendment in the complaint. My lord, kindly consider in the aspect. The criminal case, the defense is contradict the other side. If contradiction has been allowed to be cured, then what will my defense, my lord? Article 21 hampered, my lord. It will violate the provision of right to defense. Right to defense is a fundamental right. And categorically, I'm sorry.
Yes, proceed.
So my lord is well aware that in a criminal case, defense is contradiction. Every accused, this is his right to contradict the informant or complaint. If there is the lacuna or the infirmities, whatever made in the complaint, it is permitted to be corrected, my lord, then what will my defense? My defense will severely be prejudiced, my lord. I will be severely prejudiced. Therefore, that point has been taken into consideration by the Honorable Apex Court. So this is the one aspect. And here, my lord, kindly consider only complaint. And here, in the present case, not complaint. The evidence, chief. Evidence in chief also allowed to be corrected. The next paragraph 20. In the instant case, the amendment application was filed on such and such to carry out the amendment by adding such and such para. Though the respondent amendment was not, though the proposed amendment was not a formal amendment, but a submission, but a substantial one, the magistrate allowed the amendment application mainly on the ground that no cognizance was taken of the complaint before the dispel of the amendment application. There another aspect. That application was allowed before cognizance was taken. Here process was issued, charge free, evidence laid. So this is another vital thing, man. Firstly, the magistrate was yet to apply judicial mind to the contents of the complaint and had not taken cognizance of the matter.
At this stage, that considering that aspect,
Yes,
the magistrate rightly have allowed the amendment.
yes.
That is the case. right?
Because that cognizance was not taken. Here in my case, cognizance taken, evidence laid, and evidence was also allowed to be amended. So this my contention is that the order passed by the trial court allowing such an amendment is, my lord, out and out illegal and violation of the ratio laid down by this court, by this apex court. And the,
Kindly show us in the evidence, it was also the said amount was considered,
yes, ma'am.
because matter relates to 40 lakhs 30,000
Yes, yes,
and
that,
4 lakhs 30,000.
that is, my lord, easily your lordship will find. Trial court order, page 37. First trial court order,
Just a minute. Just a minute.
page 37.
Where is the complaint? Please show us the complaint.
Page 20. And the amendment was made, page 23. Paragraph 7 and 8. Page 23. Here it is written 40 lakhs 30,000. My lord, got it, man. And evidence, chief, page 27. 27 and 32. In page 27, this is affidavit submitted. Page 29, relevant portion, allowed to be amended. Page 29, evidence of PW1. Evidence in affidavit of PW1. Madam, got it.
Yes.
And then page 32 is the evidence in affidavit of PW2. And relevant portion is page 34. And page 37 is the trial court order. Here I am just saying the relevant portion is page 38. page 38. May I read?
Just a minute.
Magistrate order, relevant part, page 38. Consider the above discussion.
Yes, page 38.
Yeah. Consider the above discussion in the interest of justice, very serious, my lord, this interpretation. And as it appears to be bona fide clerical mistake, the prayer of complainant is allowed. Accordingly, prayer of the complainant in petition number such and such is allowed, and complainant is allowed to correct the same in the complaint petition as well as in the affidavit in evidence of PW1 and PW2 under his own or his engaged counsel hand and signature in presence of both side and bench assistant of the court. Interest of justice, my lord, this is a very wide expression, my lord, no. And then your lordship kindly turn to the impugning order, session judge. Page 11. I am reading from page 14. Page 14, two paragraph, 7 and 8. During argument hearing, learned advocate for revision petitioner has submitted that in the CRPC, there is no provision for allowing an amendment whatsoever in the nature, and by allowing the prayer for amendment, learned trial court has exceeded its jurisdiction. It is also submitted that the petition for amendment of amount such and such was substantial in nature, and as such, allowing the amendment has certainly caused prejudice to the revision petitioner, and as such, the impugning order needs to be interfered. It is further argued that the learned trial court has wrongly relied upon the case case S.R. Kumar that I have relied upon. Paragraph 8. On the other hand, learned advocate of the respondent, placing reliance on the same judgment and judgment passed by Honorable Bombay High Court, has argued that learned trial court has rightly allowed the amendment. It is also argued that correct amount was mentioned in the demand notice issued to the accused revision petitioner and at some part of the complaint. However, only at paragraph 7, amount is wrongly written. So this is the submission. Now, page 18, turn to page 18, my lord. Your lordship may kindly turn to page 18. Paragraph 16. By keeping the above in mind and the fact the foundation of the case, that is, issue of demand notice was made by mentioning correct amount, and that the complaint petition also correct amount was mentioned at 2 places and wrong amount was mentioned at only 1 place. It is clear that proposed amendment is in no way going to cause any prejudice to the accused revision petitioner. Same is mere formal in nature and apparently due to typographical error as mentioned in the petition for amendment. Considering all above, I held the allowing the amendment was in the interest of justice. So it is the finding of the session court that no prejudice will be caused. My lord is aware that the time, date, amount, these are the issue that we can put to the a complainant or his witnesses for contradiction. And these are our vital defense. If I'm sorry. If, my lord, that practice is going on, my lord, then there will be 100%, my lord, conviction in all and each and every case. I am not on merit. Whatever is there, parties will let their evidence. I am not on merit of the case now. I am only single point. My point is, I am arguing only single point. That whether amendment can be allowed at this stage. There is a categorical finding of the Honorable Apex Court that no, that cannot be after taking cognizance. Yes, before taking cognizance, all right. Had it been before taking cognizance, I would have no case at all. So this is my argument, my lord. The another case that I am relying upon is 2008 Supreme Court AIR 3086. Here only one single paragraph I have written, paragraph 30. Here also, my lord, amendment was sought at the subsequent stage. 2 lines only. The court had no jurisdiction to allow amendment of complaint petition at a later stage. Paragraph 30. The lordship got it, my lord. Therefore, the High Court was not correct in taking the aforementioned view in the fact and circumstance of the present case. So, when cognizance is taken, evidence has been laid.
How the second case will be applicable because it relates to amendment of the complaint petition to incorporate section 420.
Yes.
Leaving aside the section 138 of
One.
the NIA. The cognizance was initially taken under the 138 notice was issued, but subsequently that amendment was allowed.
Yes.
So that is why the Honorable Apex Court came to the finding. At a
It
later
is
stage.
relevant, my humble.
Because at a later stage means it had come to that proceeding when evidence was taken and everything was there. So at that moment, if any application is filed to renew in section 420 IPC, it is not proper for the amendment. In that regard, that judgment has been issued. Facts of that case is.
Yes, of course, difference. But what is the ratio laid down? That is my argument.
You are saying at a later stage.
Yes. What is the ratio laid down? The first point is, there is, my argument here only, my lord, 3 points. Your lordship kindly note my submission.
No, we have
That,
seen.
I don't know how
First of all, you have said in the previous case that we said,
to,
is that
after all,
it's a case,
judgment,
cognizance should not be, that amendment should not be allowed after the taking cognizance.
Yes.
That is your first case. The second case you said at a later stage, that means also you want to indicate that it is after the taking cognizance of the
Yes.
case. So in these 2 cases, complaint should not be allowed to be amended. That's your ground.
yes.
And if it is now allowed to be considered the violation of Article 21, because the contradictions are there,
Yes.
whichever is already there.
Yes.
You will not able to.
Yes,
because
contradict
it will be contradiction which is there already, it will be allowed to be curing that defects.
Yes.
So that way you are saying.
Yes.
Right?
So this is
Anything
my
else?
3 point, my lord.
Okay.
First one, severely prejudiced, and Supreme Court says other prejudice that has to be looked into. And second one, after cognizance law. So this is my argument, and I am not on the merit. Whatever is the case will go, my lord. Trial will proceed. I am also not wanted that trial will remain state for unlimited period. So my lord may decide it. This is my humble submission.
Yes, Mr. Raja. First of all, what Mr. Rajuddin has clearly mentioned that
Lordship.
in this particular case,
Lordship.
taking after cognizance, right?
Okay.
The learned magistrate had allowed that amendment. And thereafter, against that order, the matter was challenged, revision petition filed. It was rejected by the learned session judge, and that stage, aggrieved petitioner is here, the respondent is here. But tell us, Mr.
Lordship, may I kindly see the section 145, subclause 2 of NI.
Hmm. Yes.
145, evidence on affidavit.
Hmm.
So this is also an Act case, so I'm referring to this section, Lordship. Subclause 1, notwithstanding anything contained in the Code of Criminal Procedure, the evidence of the complainant may be given by him on affidavit and may, subject to all just exceptions, be read in evidence in any inquiry, trial, or other proceedings under the said code. Now, subclause 2 is important, Lordship. The court may, if it thinks fit, and such and shall, on the application of the prosecution or the accused, summon and examine any person giving evidence on affidavit as to the facts contained therein. So here, if your lordship see the contents, to verify that aspect, that petition was filed by the complainant. Because lordship may kindly see paragraph 5 of the complaint, that is at page 22.
Yes.
Page 22, your lordship will
No, we
find
have seen
that,
those complaints.
yes, 5 lakhs
We
was,
have seen that in para 7,
yes.
instead of 4,30,000, that amount that was to be dishonored, it has been made 40 lakhs.
Yes, it is a typographical error for the particulars of the check. It is not said that that was demanded, because demanded and the borrowing amount that are mentioned in paragraph 5 and 6. Those facts are there. It is complainant's case is clear that 5 lakhs was taken, 70,000 was given, and subsequently 4,30,000, which was remaining, for that amount check was issued. From 5 and 6, it is clear. Then your lordship may kindly see the paragraph 7, which my learned friend is referring. Here, what the last 3 words, that after expiry of the consecutive 2 dates when the complainant again approached to the accused, then only on 7/7/2020, the accused came to the complainant and issued a check with the following particulars. So he is mentioning about the particulars of the check that can be verified from the check itself, because check number is there. They have not disputed that this is not the check number and this is not the date, and they have not issued. That fact they are not denying. The only fact, the typographical error which is occurred in the mentioning the particulars, they are challenging that part only, because I have narrated the correct facts in 5 and 6. Only when I was typing that particulars of the check, which I cannot alter. It is already there in the check. For that purpose only amendment was allowed. And the other thing they have not disputed, lordship, that check number, date, and issuing. And in affidavit also same thing, lordship, that paragraph 5 and 6, they are narrated about the amounts. And while writing the particulars of the check, details of the check when writing, that only typographical error occurred. And the learned session judge order, that what I find, lordship, that it is reason order, and after discussing the Supreme Court judgments, lordship, it was passed. And therefore no interference is required in the present case, lordship. Because the complainant nowhere said that he is entitled to 40,30,000. He said 4,30,000 he is entitled, and for that check was issued. While writing the particulars, that I am again repeating, lordship, that only writing the particulars he made that mistake. And demand notice which is there on record, lordship, that also regarding 4,30,000. And check he exhibited, that is also of 4,30,000. Had it been a case that he has demanded more money or demanded some other amount, then I could have understood, lordship. But here about only particulars of the check, that he cannot change.
না ভাই, বড়ুয়া এই আগর কালকে যে 12:30 ফিক্স করে তার ভিতর Mr. Azad, do you have a copy of the application filed for amendment?
No, that copy I do not have.
No, even the record doesn't have. That's the reason you're looking for. Do you have the copy of the amendment application filed by the complainant?
I'm checking.
We have the CR record, but in the CR record, it is not available.
রেকর্ড আনছেন রেকর্ড তো আনে আগতে ফোন করেছিল
তাহলে CR record করে দিবো।
No, I have not, only my objection is here, application is here.
Mr. Azad, can you give it to us by day after tomorrow?
By day after tomorrow.
Definitely the petitioner will have it,
Lordship.
right? Both the objection and the.
Objection probably my
Mr.
learned friend.
Rajuddin, even if you have the application, any one of you,
Lordship.
somehow it is not in this year case. By Thursday, you will be able to give it to us?
Well, 21, 22, I will be out. After,
20
before
20
or
I can-
after?
When do you give it to us?
27th.
27, you'll give it to us? Heard Mr. Ayuddin, counsel appearing for the applicant. And Mr. A. Ahmed, counsel appearing for the respondent number 2. Also heard MSS Jahanlal additional public prosecutor appearing for this respondent. Heard the matter considerably. List on 27. Enabling both the counsel for the petitioner, Mr. Ayuddin, as well as Mr. A. Ahmed, land counsel for the opposite parties, less number 2 of the claim, to furnish the copy of the petition number 2781/2021 filed by the opposite party number 2 complainant for amendment of the complaint. You have said also evidence, complaint and evidence both.
Evidence is there.
No, no. Was there any prayer for amendment of the evidence or only the complaint?
Definitely there because it was allowed.
The first petition filed by the complainant slash opposite party number 2 hearing for relevant amendment relating to the said CR case number such and such 493/2020. Submitted before the additional judicial magistrate Morigaon, as well as the objection filed by the petitioner before the additional CJM Morigaon with regard to the prayer of amendment made by the respondent number 2.
সারাদিন বন্ধ আছে। তেইশ, 24, 25, 26 বন্ধ আছে। বন্ধ করে এনসিআর করে করা নয়। আজকে তাই করি পাঠ করি। না, উপরে দিলে
You get 2781 litigation, filed by the complainant opposite party number 2 to amend the complaint petition, to amend the complaint petition at its para number 7, along with the evidence in chief of affidavits in of the opposite party number 2, PW1, and also his witness PW2 pertaining to the check amount. Along with the written objection that the petitioner filed against the said petition number 2781/2021, preferred by the opposite party number 2, as well as the copy of the revision petition filed by the petitioner before the Planet Session Judge Morigaon, Guwahati. In revision petition, revision petition being criminal revision number 09/2022, filed by the petitioner before the Planet Session Judge. Against the order of the Learned Additional CJM Morigaon. That it. 27062022. First in. CR case number 493/2020. But Mr. Rajuddin and Mr. Raza, give us the copies.
Advocate record copy from advocate, record the certified copy, it may be.
Not required, not required, because that is why you will give, you have the applications will see.
Can it be on 28 instead of 27, Lordship?
128, okay. Only for furnishing the copy. Other
Interim
cases,
order is there.
we have already heard the arguments, only want to peruse your applications.
Interim order is there.
The interim order passed earlier shall remain in force till the next date of listing.
May I pray one oil matter we take as partners, we had already have explained.
No, make it, if it comes to the other court, you make a mention, otherwise not likely to come, but anyway, if it comes, you make a mention.
I am obliged.
If argument is not,
Sorry,
sorry, on that day only for that documents.
only for the documents, nothing else.
Obliged.
My lord, I have one prayer, my lord. Since today is Friday, my lord, my next item 10, my lord, it will be taken up at 2, my lord.
Item number?
10, my lord. At 2.
There are some other matters fixed at 2. After those matters, will be.
My lord.
My lord, I had taken instructions, my lord. What happens, my lord? They used to file application before the court. And the payment, whatever is made, my lord, is being endorsed in the petition itself. So I have a Xerox copy, my lord. But the actual endorsement, if I have to present before this honorable court, I have to take the certified copy. my lord. These are the last two applications, my lord.
You have to tell us how much amount you have paid.
8,000 I am paying, my lord, 8,000.
When?
It's a petition, my lord. Although there is no, my lord, but my lord, learned friend will agree, my lord.
So last 2 months, they have paid 8,000, last 2 months, otherwise 5,000, my lord. And there is an outstanding amount of 1,03,000. my lord. That is the outstanding amount.
That my lord will decide.
Oh, there is an order of.
Mr. Raman, can you give us the details because you are receiving
Yes,
some
my
evidence,
lord.
right?
Yes,
So after the order of the learned court,
My lord,
how much you are receiving?
my lord, my lord. I will, give me some time, I will,
When?
a week, my lord.
Give us a date.
For the Sipsagar, my lord, so they will have to send it after. Next Friday, my lord.
Next Friday is a holiday.
Court will reopen on 27th. After
27th.
4 days holiday. On
27th.
27th, you will be able to give it to us?
My lord,
Okay, we'll make it on 28th for you.
my lord, my lord,
After the order of the learned magistrate,
my lord,
when the petitioner started paying,
Yes.
my lord.
okay, instead of 7,000, how much he's paying?
Right.
And as on date, on that date, what was the? You can give it up to the month of July, the area amount,
Yes, your lord.
right?
Yeah, I will submit.
You give us in a chart manner.
My lord, I will do it. Should I file an affidavit or just a chart? Just a chart?
That will do. Need
My
not
lord,
file it.
my lord.
Heard Mr. R. Chakraborty, counsel appearing for the petitioner. And Mr. A.W. Aman, learned counsel appearing for the sole respondent. Oh, no. As a
R2, my
respondent.
lord, respond number 2.
Also heard MS as Jahan Landison Public Prosecutor appearing for the state respondent number 1. Yeah. Learned Subdivisional Judicial Magistrate at Nazira Sivsagar by its order dated 06/07/2022, passed in this case number 26/2020, preferred by the respondent number 2. Claiming monthly maintenance for her from the petitioner and their minor daughter under section 125 CRPC. By directed the petitioner to pay an amount of rupees 4,000 per month to the petitioner, sorry, to the to his wife, the respondent number 2, and rupees 3,000 to their minor daughter until further order. Every month as per Gregorian calendar. With effect from date of passing of the said final order I-06072026. Agree with the said order of the learned SDJM within bracket M Nazira Sivsagar dated 06/07/2022. The petitioner filed a revision petition before the learned session judge at Sivsagar, being criminal revision number 25 within bracket 3 of 2022. And the learned session judge, after hearing the parties by order dated 01/02/2023. Dismiss the said revision petition of the petitioner. Upholding the order of the learned L.T.M. Friday dated such and such. Pertaining to the monthly maintenance payable to the opposite party number two. Sorry, respondent number two and in their daughter, minor daughter. This satisfied with the same finding of the learned as DJM such and such as well as the learned Session Judge Shivsagar. The petitioner has filed this criminal petition. Stating that the learned SDJM Shivsagar, while passing the final order dated such and such, as well as the learned Session Judge Shivsagar, putting the impugn judgment and impugn order that is 01/02/2023 committed illegality in not complying with the judgment of the Honorable Apex Court in the case of Rajneesh versus Neha. Decided on 20, not 20, 11, it's 11. 4/11/2020 reported in 2021 to SSC 324. Mr. Chakraborty, learned counsel appearing for the petitioner submitted. Since the impugn judgment of learned SDJM, impugn order of the learned SDJM, the impugn judgment and order of the learned Session Judge, it is such and such and such, or after the order of the Honorable Apex Court in the case of Rajneesh and versus Neha, without complying with the said, with the directions passed in the said judge, both have to be set aside and passed. On the other hand, Mr. Aman learned counsel appearing for the respondent number two, applicant wife of the petition number one, submitted that only after considering the fact that the in evidence that the petitioner has sufficient means, a truck, tea estate, and other properties, having sufficient annual income, the learned magistrate passed the impugn order dated such and such, directing the petitioner to pay a monthly maintenance of ₹4,000 to his wife, i.e. the applicant respondent number two and their minor daughter, at the rate of ₹3,000 per month, which effect from date of the order dated 06/02/027. And as such, the decision of the Honorable Apex Court in the case of Rajneesh versus Neha Supra will not be applicable in the present case. We have heard both the parties at length. Yes, Ms. Jahan, what do you have to say?
Because Rajneesh Neha, as it provides the entire procedure. Anyways,
Mr. Chakraborty is saying it was not complied with because their all lordships have directed that before issuing any such order of maintenance, they're supposed to have, fill up those three formats as
Yes.
been prescribed in the state judgment. Above that, the state judgment also said that it will be applicable for all pending matters
Yes.
before the court of magistrate, before the court of any other session court or under the court of family court. And that has not been complied with.
Many cases I've seen. I mean, I
And
don't know.
the other contention of the petitioner is that this application is under section 483 statute. So considering those aspects, this both the orders should be.
Should
set
go.
aside. At the same time, Mr. Aman is also saying that if the petitioner doesn't pay him the maintenance for herself as well as for the child, they will be in a destitute condition. They will have and two more process child, so they will not able to survive. What will happen? The matter goes back.
This is the purpose of the maintenance,
Right?
but
That's what he's saying. But anyway, we'll pass the order, but at the same time, that is why you're asking what amount he's paying. We want to know first, then we'll consider.
that case, I think, can be remanded also. They will again submit the documents there.
We'll consider
Yes.
the other process, but let us see first, because whether as of now, there is no stay. And then whether the petitioner is paying that amount
That
regularly to the
has to be seen.
investment number.
And in fact, my lord, this is the present scenario. There are many other cases, many other in courts, my lord. They don't follow, my lord.
Assets and liabilities are
Yes.
not produced. I mean,
We'll look into that
Yes.
while you're passing the final order.
Yes.
Okay, leave it. I'm not to leave that. But tell us, Ms. Jahan, what will be the status if a judgment is passed without complying with the order of the honorable apex court? Directions passed.
Just to go.
Mr. Raman is arguing that only on the basis of evidence that order has been passed. Do not comply with the other parameters of the judgment.
These are only guidelines, which of course mandatory, the courts has to follow. This is what Rajneesh, I
No,
think
it was
it's
passed
written.
under Article 141, my lord.
It is under 141.
Specifically,
Acha.
exercising that
It's a
power
law.
of the honorable Supreme Court under Article 1.
So in that case, of course, violation will not ipso facto make it invalid.
Anyway, we'll pass the final.
Lodge, I'll also look into.
27, 27.
Lodge.
Deeply offline.
Mr. Raman, on 27, you will be able to give
I will submit.
list on 27. Enabling the respondent number 2 to apprise the court the monthly maintenance she is receiving from the petitioner, the amount and the dates, with the amounts and the dates.
Allowed to pass as a,
For further consideration.
Deeply offline.
May I please, your lordship? Lordship, matter may be adjourned for 2 weeks to obtain the instruction from the client, your lordship.
Yes, madam, tell us whether the petitioner is complying with this order.
Yes.
When did he appear before the trial court in terms of the direction passed by the court earlier on 13th of June 2023?
My lord, Mayor, Lordship, my lord, initially petitioner appeared, my lord. Subsequently, my lord, it was taken custody, my lord. Thereafter, we are unable to contact the petitioner, my lord. And last day, August, he also in custody, my lord. First time he appeared and paid, my lord, and was direction of this court's order. Subsequently, he was absent, and at present, my lord, I am unable to contact. What is the, he was complied with court's order or not, my lord. And his contact number also, my lord. First installment he was given as per direction order, my lord. Then, my lord, he has failed perhaps, my lord. One installment paid, my lord, 29/4/2020, the 30,000 is paid, my lord. But next installment was 1/7/2020, 10,000. Again, NBW was issued and my lord, he was arrested and in custody, my lord.
He is in custody.
My lord, 2 times he was custody, my lord. And at present I was unable to contact my lord. First time he was custody and then he paid 30,000 and bail bond. Secondly, he was again custody, my lord. And after this order, my lord paid, first paid, my lord, 30,000, next my lord, 10,000, last 10,000. That information I have, my lord, last payment, my lord.
You want time?
Yes, your lordship.
How much you have received? Any information?
No, your lordship.
Why aren't you taking time? Where you want to take time? Where are you praying for adjournment?
Lordship, my senior is out of station, your lordship.
What's your good name?
MD A Rahman, your lordship, on behalf of MK Hussain.
Heard Mr. Chali. Counsel for the petitioner. Your good name
MDA Rahman Rashid.
and Mr. MDA Rahman, learned counsel on behalf of Mr. MK Hussain. They submitted to Mr. Rahman. The pleading counsel, Mr. MK Hussain. For the respondent number,
Full respondent.
for the sole respondent is out of station. Place for adjournment, they are allowed to list after 2 weeks. Look it over.
Hello.
Just for quashing of the FIR. Oh. But again, I think 156(3) will come into picture. Oh. Yeah.
Please come straight to page number 49.
49, yes.
Yes, that's the prayer in vernacular.
Huh. Not to register, but then to arrest. It amounts to police investigation.
That is what 156(3) says.
This is why I'm saying this will come, and there is no averment that they have taken recourse to other things. It's a complaint petition also. And nowhere subject to correction, they have written that they have taken recourse to other methods.
Okay, last 2 days I didn't get a time. There is a judgment of the apex court,
Mm-hmm.
very clearly mentioned. Not only that, the 156(1)(2) to be followed before the concerned officer for registering and thereafter the SP. But there is also a judgment specifically when these kind of complaint petitions are filed without mentioning 156(3), but with this very specific prayer
Contents are very specific.
that the case has to be forwarded to the concerned police station for a registration to arrest him or arrest the accused person and they proceed and this. Then that has to be considered under 156(3) itself because the prayer itself shows.
Although not in so many words, they do not write 156(3), but the content shows.
So
Lordship
that
is
case-
trying to find out that judgment.
That is very clear. I read, that's what I remember. But anyway, but here it is very clear that it is under 156(3).
156(3).
Now, the law is settled without mentioning 156(1)(2). How can I go for 156(3)?
Here, I don't think so any orders are passed. He has not annexed. It
No,
is
but,
still at a nascent stage.
No, the actual matter was referred to the, when this was passed. When the order of the magistrate.
Equity, man. Equity procedure होना है तो nascent stage or रहेगा. एकदम प्रथम stage. Oh, that I can take.
We'll go to my.
Bail is on us.
Watching with it.
কি affidavit?
Very good is a compromise, but you are putting a number of it.
Compromise is in.
Not compromise, even.
বহুত হয় থকা ন।
Yes, tell us whether
My lord,
to interfere at this police station case or not.
my lord, my learned friend can, learned PP may take instruction from the police, how much
What for? What instruction?
lordship,
What instruction is required?
because they have,
Tell us legality and illegality how to this particular matter.
that too also lordship, nothing, no record is.
You know, you have handled hundreds and thousands of cases earlier.
My
Right?
learned
With your
lordship,
experience, tell us, we should allow this petition or not?
lordship, perhaps lordship, as per my instruction, my WhatsApp message shows that the police perhaps filed FR like. So let my learned friend, as the time saying that learned PP may take instruction that whether the police has submitted the FR.
Are you aware? The FR has been filed.
No, but I'm not aware of that. Only one thing, my lord, I want to submit is, my lord, the petitioner number 3 has in the meantime expired, my lord.
Ms. Dahan,
Lordship.
will you able to get any information?
No, because, but they have not taken ground of that, that 156
One
B.
56, they have.
Doesn't matter.
Yes,
But
doesn't
that,
matter.
we can look into as a petition, like it was 482 petition.
482 petition or even this court may have.
It's a point of law point, because I can take the instruction, what is the fate of the case till now.
What's your good name?
D. Kolita, my lord.
What Mr. Sachin, for the petition. And
করিমগঞ্জ।
Pretty much. I think.
and that says Jahan, an additional public prosecutor.
Registered inspector. Karimas town of the way.
করিমগঞ্জ PS, no?
Or
Case number.
the respondent number
Three
one.
89. We have to come with the. Body. Yes, case number 318.
22.
Also heard Mr. K. Majumdar, not counsel for the
Respondent number 2, lordship. 2, lordship.
complainant, respondent number 2. Mr. Majumdar, on instruction submitted in that police, after investigating the matter, in the meanwhile submitted final report in Karimganj Police Station case number
Out and out.
0389
খালি forgery চলছে।
Forgery police and not out.
public 2022.
Forgery.
Corresponding to GR number 1188 public 22. That was registered
না, good.
on the basis of
Eh?
a complaint filed by the respondent number 2 and being forwarded by the learned additional CJM Karimganj. Okay, I will get the information.
Lordship.
Something.
I'll get the
On
email
the next
next.
date fixed.
Oh.
On the next date. I mean, Zahan Lada, Deputy Public Prosecutor, shall apprise the court about the status of said
That's the number of the license.
Karimganj PS case number such and such, of such and such. Under sections ভরাই দিবা। লিখে দিয়ে পরে কি দিবা? 120B oblique 420, oblique 406, oblique 467. Oblique 468, oblique 471, oblique 294, oblique 506, oblique 34 IPC. Corresponding to GI numbers as such. Copy of this order to Ms. Jahan. Get the copy during the course of it.
There was an interim order, my lord.
What interim order? Already final report has been filed.
That,
Next, Lordship, at what date, Lordship? Date may be pending.
CR case 591, why CR case 591?
but,
Why CR case 591? What
It was
will happen?
originally CRK, it was referred to the police.
That proceeding will be no, how can it be posted? Because thereafter it has been registered as a police case.
They have taken bail as well, Lordship.
We have seen that. Ms. Jahan, when it will be possible for you?
Any day next week, I'll have a telephonic conversation.
No, get the report.
What?
Let us, if it is filed final report by which?
I'll get that.
Sorry, 20s.
22nd?
20, yes, 22nd, Thursday. Lordship.
Okay.
Mm-mm.
Item number 5.
Is 5, Lordship, I've got
Information from Kaki
report.
Police Station.
Kaki police station, but the fact remains that it's still with the FSL. And the mobiles are there, FSL Guwahati. And so what I have told them to issue a reminder and get a report as well as the mobile soon.
When can we expect it?
I've told them to do it by next week.
Okay.
So Lordship will, Thursday.
Okay, we are fixing it on. We'll give you some time.
Lordship,
Get the report by
22nd or 27th?
2nd of September.
22nd of?
2nd of September.
Or 2nd of, yes.
Because in
Lordship.
the meanwhile, the FSL might send a report.
Lordship. I've asked them what the FSL will do. They said that some Facebook page, whether it was sent through that mobile will be seen.
Okay.
Now, whether FSL can find out that, I have my reservations.
That the petitioner also partly admitting, yes, I have made some post. So what necessity, my lord, for further inquiry? He was arrested, he was released on bail.
Heard Mr. Sigal and counsel appearing for the petitioner. And Mrs. Jahan and additional public prosecutor appearing for the state. Ms. Jahan on instruction. Stated that the
There's a 3-page instruction.
that is
It was approved.
এটা বিহাৰী আহি 1 হৰণ দিলে এটাই কেম্পত মান খাই পৰি থাকি মোগলক হৰাই দিলে আমাৰ গৌৰৱশালী জাতি দেই কিনো ডাঙৰ মোগল মই কৈছো ৰিমাইণ্ডাৰ কিয় নিদিয়ে কিয় মাজতে বোলে in fact, the police officer said that initially when they sent, they got a reply letter that they don't have the technicians to do it. Then it was sent back. Then they had again resent it to the FSL. It was, I was a technician.
that the mobile phone of the petitioner seized in connection with Kaki Police Station case number 92/2022. Still with the Assam with the Forensic Science and Laboratory at Kailipada, Guwahati. For its necessary report. Full stop. released on 2nd of September,
Hmm.
enabling the officer in charge or enabling the it will be the officer in charge or superintendent of police?
Officer in charge.
Officer in charge of Kaki police station numbers and such? No, investigating officer of
In fact, it is with the IO, but then
investigating officer.
I spoke to the OC.
To place the up-to-date status relating to the mobile handset of the petitioner, mobile, only Oppo, OPPO.
No, Redmi and Realme.
There are two mobile phones.
Mobile.
Two mobile phones.
No, no,
The two mobiles.
no, no.
Whether the two mobile handset.
Oppo and
Oppo, Reno X5. AI. And
Only one mobile, I'm told, Lordship. Oppo Reno.
there is only one, it has been shown.
Acha, one.
One mobile. Only but it's in connection with features and such. Copy of the communication dated 18/7/2024 in 8. No, 18/7/24 of the superintendent of police. No, of the IO of Kaki PS case number certain. Placed before the court today be kept as a part of the record.
What?
We have it on certain.
Lot.
Item number 22 and 23.
Call it.
Good afternoon, my lordship. Opposite.
Yes, Ms. Zahan, can you have an information
Okay.
before we pass any order by 3:30 and all regarding a police station, Jalukbari Police Station case number 572 of the 2016. Whether any search sheet file or final report file, if file, whatever, when it was filed with the number. Jalukbari PS case number 572 of the 2016.
572. But this is not the, I mean,
No, there's a
there are
second case.
second case, yes.
What has happened here, the petitioner initially filed a FIR
19/7.
on 24th of, no, sometimes in 2016. And before the Jalukbari police station, which was not acted upon. So the petitioner filed this criminal petition for a direction to the concerned authority to take action on that.
Hmm.
In the meanwhile, the accused,
Hmm.
the FIR,
Hmm.
filed a cross case against the petitioner.
Acha.
In that case, Jalukbari police station took prompt action
Hmm.
and filed a charge sheet
Oh.
against the petitioner,
Hmm.
wherein cognizance was taken,
Hmm.
against which the petitioner filed the second criminal petition. Both are pending.
Huh.
So that is why the petitioner filed the earlier criminal petition
Hmm.
that if any action taken, they have not charge sheet not filed,
Hmm.
no final report. That's why she paid before the court the second criminal petition, that was the
Huh.
first criminal petition.
Hmm.
So we want to know
Hmm. What happened to 572?
572.
Lordship.
My lord, 572/2016 is the first case, my lord, main case matter.
We know that.
Huh.
My lord, it is astonishing matter. It is astonishing matter that our case is pending. No case, no charge sheet is before the CC court. my lord.
Just let us get the information.
No.
We'll have it around 3:30.
Lordship.
Okay.
572. 572 runs 16.
My lord, direction order is IA in Annex 6, my lord. Annex page 1922.
Where you have filed IA?
In IA petition, in IA petition.
Which IA you have filed?
In petition number 1110,
That is a different case. We are talking about your criminal petition 1513, Mr. Das.
My lord, as per order, my lord, as per order dated 3/1/2022, criminal division 1530. It ordered that by this petition filed under section 42(2), the petitioner paid for directing the Jalukbari PS to take necessary action in respect of the Jalukbari PS.
Mr. Das, in which case order was passed? In which criminal petition the order was passed?
In criminal petition was 1513. 1513/2019.
On when? On
On
3rd of January.
3rd of January, yes, my lord.
Yes. Yes.
The 572 charge sheet is in it.
Why not?
Still investigating. Second one of charge sheet is in it. Second one of.
Has the same possession agency?
It's on now.
तो चार्जशीट पर ऐसे एफआईआर नंबर तो हो
Yes, get that information that you do.
Lordship, I've already sent Ms. Das to get the information.
We'll take it around 3:30.
Lordship.
My lord, kindly, I want to get some point, my lord. Kindly, criminal petition, page number 10.
Mr. Das will take it up at 3:30.
After I get the information.
Problem.
No, repetition is charge. That take a charge. Main petition की तरफ देखिए मुझे बोलिए इसको 3 मिनट 30 मिनट है बोलो सीधा रख के सही करो तो सीधा रखो तो होगा सीधे आपने तो मतलब 9 और 18 Madhu. Madhu. Someone appeared for the response, yes.
Yes, my lord. The basic issue, your lordship, on the last occasion was that
Yes,
they have to satisfy the honorable court, my lord, why the affair has been filed after lapse of 4 years, my lord. Particular at page 61 is the affair.
Ms. Jahan,
Lordship.
do you have the copy of the petition?
Yes. Lordship.
Go to the affair.
61.
61.
61.
English.
English bill as a character. Comment this one.
Ejahatari Hamanpuru Nivedu Neju. And that I am resident of this person after knowing that I have to hire a gentleman. Various sources taken his name. Daughters in the within a year, taking the one, Lordship, he has taken money to give jobs to his daughters.
Which year?
This is 2023, 11th of May. 11th of May.
The FIR discloses that within 1 year,
He promised to give the jobs.
within 1 year, promised to give the job, but he failed.
And after that, he did not answer his calls and all.
But he failed to show any document issued by the government. And that did not pick up the phone, return. So
Then the investigation started, and what I am told is that the accused admitted that he had taken money.
that's before police.
Huh.
That
In his
admission-
161 statements.
Will it be admission?
No, that will be a statement because 161 is any person. That will be only a statement. It is not admissible in evidence, but lordship, some 161.
This one. The next for us. Different time, different statement has been made.
Oh, so many statements.
Someone said Nazrul, someone said speaking.
Do you have the 161 statement with you?
Yes, Lordship, my
have
learned
an
friend has given me. One he has annexed, perhaps there are so many 161.
We have the record for you.
This I have. I have the certified copy. Perhaps this is the one which was recorded on 6/5 meaning, get a record is it?
नाम क्या
Islam Ali.
No.
Islam Ali तो accused
Accused. Islam Ali is the accused. এখন কি তার নাম কি? Islam Ali. ওপৰত লিখা মানে মই বৰ্তমান ভাৰতীয় ৰেল বিভাগত কাম কৰো নেকি?
Now, do you have the, come to page number 76.
আচ্ছা। 76 is, this is the complainant statement.
Yes.
ওপৰত উল্লেখ কৰা মতে আৰু ইমান হয়, মই ব্যৱসায় কৰো, মোৰ জুৱা ইমান ইছলাম আলী পিতা সোয়েনসো মোক প্ৰলোভন দেখুৱাই মোৰ ছোৱালী দুজনীক ৰেলৱে বিভাগত চৰকাৰী চাকৰি দিম বুলি আমাৰ পৰা 20 লাখ টকা
ঠগবাজ কৰি নিয়ে।
ঠগবাজ কৰি নিয়ে। টকা লোৱাৰ এবছৰৰ ভিতৰত চাকৰি দিম বুলি কৈছিল, কিন্তু এতিয়ালৈ কোনো চাকৰি নহল, কাৰো চাকৰি নহল। মই ফোনত বহুবাৰ যোগাযোগ কৰিব চেষ্টা কৰিছো, যদিও কোনো ধৰণৰ ৰেছপন্স নিদিয়ে। মই মুঠ 20 লাখ টকা
কৃষিভূমি
কৃষিভূমি 14 বিঘা বিক্ৰী কৰি This is
টকা কিনি দিওঁ। Then come to the statement of another witness, Nilkamal Roy, son of the informant.
I am a businessman. Islam Ali asked her so and so to my two sisters.
Auntie Deepika or Rekha something. Come to page number 78.
ভন্টি দীপিকা আৰু ৰেখা ৰেলৱে বিভাগত চৰকাৰী চাকৰি দিম বুলি কৈ 20 লাখ টকা বিচাৰে। আমি মাটি বিক্ৰী কৰি
টকা লৈ টকা খিনি দিওঁ।
প্ৰথমে আমি 15 লাখ টকা আমাৰ ঘৰতে মোৰ মা দেউতা
মোৰ দুই ভন্টি সাক্ষাতত
আমি দিওঁ। 21 এপ্ৰিলত চাকৰি দিম বুলি কয়, লগতে ধন লৈ
যায় আৰু ডকুমেন্ট এফিডেভিট কৰিব লাগে বুলি 5 লাখ টকা বিচাৰে। আৰু খালি দলিলত মোৰ মা আৰু ভন্টি
ৰেখা ৰয় চহী লৈ আহে, লৈ যায়।
পিছৰ 5 লাখ টকা পুনৰ গহনা বিক্ৰী কৰি অলপ কৰি দিয়ে।
Some contradictory statements about selling the land and all. But land selling is there. আমি মাটি বিক্ৰী কৰি 17 টকা নে লৈ then Mahadev, that Purna Roy he saw a packet was given in the hand of Islam Ali for providing job.
81. Page 81 contradictory. Nazrul Ali came to my house.
Ratul does.
Now Nazrul.
I am a driver. I was working at the shop of Nilkamal. And I drove vehicle. That day I was washing. Nazrul came to my owner's house. And I saw rupees. The man was given in a paper wrapped in plastic. Asked the family, Nazrul Ali. It's a belegando. Asked the family member whether there is.
I along with Rekha and Deepika Roy generally went to Ramya in a vehicle and gave 50 to Nazrul in hotel.
Nazrul and Islam are same.
No. Totally different.
অসমীয়াখনত নজৰুল আলী। any statement, every person giving any statement. If the statement is not admissible in evidence or not, before even before the press. Okay, if the statement can go on. Section 24. No. I'm giving that number, one person. I'm not going to. No, what was it one person? Thirty. জানি, কবে করবেন? আচ্ছা, এইটো পুতেকেটো কৈছে, পুতেকে কৈছে। আরে এইটো পুতেক কোন পড়লো যে? দুই ভনী, দুই ভনী। পূর্ণ নীলকমল বা son of
Ratul.
son of the complainant. Son of the complainant.
No.
78.
70. Nilkamal Roy. 77. No explanation for delay, madam, of 4 years from the alleged cause of action.
মানি সুটো ফাইল করেছেন?
আমি করেছি।
হ্যাঁ।
57 itself says, my lord, the cause of action in the year 2019. 3B.
Where is the search sheet?
My lord, that your lordship.
Page 70. English is page 70. Yes, 73.
Vernacular lordship will see at 75 starts. Vernacular 73.
Yes, tell us just around giving of 20 lakhs rupees just by 161 statement, making after 4 years. Sufficient without proving any valid document regarding such transaction.
No, first of all, 161 statement of the complainant and its son is there, making out a case that he has taken 20 lakhs.
When?
Of course, 2019. Thereafter, he said that I have been making many phone calls. He was trying. COVID period also came. There, of course, delay is there. There is no reason. Reason is there that I have been trying to have a talk. He is avoiding. But he did not write that there, because of that, there is a delay in lodging the FIR. Of course, that statement is not there. The requirement is that if we can show any reason for the delay.
Is there anything?
His explanation that he is trying and plus the COVID period came. Of course, there was no bar in him to lodge.
nowhere
the
mentioned.
Nowhere mentioned, but 2019 and 20.
19 there was no copy.
20 it started.
It was over by 28th of February 2022. So
Delay, because there is a delay. And he writes, I am now left with no option.
taking money.
Money suit is going on, my lord. He filed WS also. And lordship is aware, my lord, there is a good many judgment of honorable apex courts, my lord, where the civil suit is going on, my lord. The criminal cannot proceed.
Today is a statement, Lawson.
All.
Acha.
It is there very much in the record also.
Record about what?
There are 4 witnesses only, 5, no? Master witness.
Relating to what?
My lord, LCR from trial court.
That
Scan
is
court.
That is your.
There are only 4 witnesses as per the charge sheet.
LCR has come from trial court.
It date to get here. Date in order. But his statement before the police officer will not be taken over. Any statement, no? Any statement, no? Section 24.
Notice Kumar. Pass. Sandeep Singh. Sandeep Singh, আরো একটা কর।
Yes, tell us why should not interfere? Why should not we interfere? Tell us.
Okay, now, already we have said that last part of the in the 2022, we did not receive our phone calls, let's say. We're trying to avoid us, let's say. That's why we have filed to lodge this FIR in the year 2023, let's say.
That's the only reason not to interfere with this particular matter.
Okay,
Tell us.
and next petition, Lordship, they are trying to color this as a civil nature case, Lordship. After knowing about the filing FIR, when the police of Kumarigata outpost visited his house, then he filed a civil suit, Lordship. After 6/3/2023. In paragraph number 7 of his petition, itself it is there, on 6/3/2023, police of the Kumarigata outpost visited his house, Lordship.
Yes, tell us then.
So, Lordship, it is not a fit case for.
Why? Tell us.
And it is not a civil nature case, Lordship.
You have given money.
Yes, Lordship.
How to prove it? By oral statements.
No, Lordship, in police station, we have submitted one recording, Lordship. On pen drive already submitted, but
there is no mention in the search sheet regarding that.
it is not mentioned, Lordship.
Then.
But it was submitted for the police station, Lordship.
It is not an issue there before because the IO did not mention about it in the search sheet. Then. What are the materials to prove it? Just by mere oral statements of 3 or 4 persons. Tell us. How will you prove it? How the prosecution will prove it? Only because his statement because of the informant, his son, and 2 of his old employees.
Accused already admitted it, Lordship.
Where?
After getting interim protection from the Honorable Court, he appeared before the police station and stated that he taken money from us.
Is it?
Yes, Lordship.
This is a common phenomenon. Always the police will force you to write like this in a police station.
Lordship, after getting interim protection, there is no force, Lordship.
That's simple.
Before this, he
Whether
was
statement
absconded.
was recorded before the magistrate.
It was not registered, but before.
Katika, please tell us. Please tell us legally whether how much this particular document 161 statement of the accused will be enforceable.
It's not enforceable regarding prosecution, Lordship.
Yes, madam,
Noted.
tell us. Any material to proceed further, because what happens before taking cognizance of the case, it is the duty of the magistrate to verify not to the extent of evidence, reviewing the evidence, but prima facie he has to be satisfied.
Prima facie from the
Now,
police
prima facie
records.
to be satisfied, if four people says he has taken money, will that be enough?
Prima facie on the basis of the police records. Now, I've got a decision long back that 160, even accused statement will fall under 161 because he is any person, his statement can be recorded. But again, it will be hit by section 24 of the Evidence Act. Any statement will not be admissible. Trying to find out the judgment, how Supreme Court dealt with it. Otherwise, his statement is there along with the statement of the prosecution witness.
See, only thing before taking cognizance, the magistrate is required to find out prima facie materials are there. That much. Now, prima facie materials, as you know, in 482, it will be again different. Whether that will, you have sufficient materials before the magistrate. Right? To prove the case on that. Then whether these materials are sufficient, that much only you are supposed to tell.
Because we are left with only the statement of the son and the father. Complainant and his son. Driver, he is talking about someone else, Nazrul.
That's right.
Other person doesn't know. So there were only 4 witnesses. Only on the statement of son and the father. The son says that he came and
There
took
are
and
contradictions again, even in 161. Forget about that.
yes, how the amount was given in that context. But as far as taking the amount, there is consistency. And what we need is only a prima facie materials.
In that regard, tell us.
Huh.
Okay. Yes, Mr. Barhuya, any other thing?
My lord, there is a 2-3 judgment, my lord, lordship is aware, my lord, not only that, my lord, the first and foremost, my lord, no material to show prima facie, my lord. Apart from that, my lord, there is.
That is your claim.
My lord, my claim,
Your
I have.
claim is there is no material.
No, my claim, apart from that, my lord, had it been a genuineness, my lord, my legal notice, 3 legal notice I have given, my lord, before in the year 2022, that is the dated, my lord, 25/2/22. They did not reply, no counter claim in my civil suit. I said they have taken money from me to return, but now they said this.
Where is your civil suit?
My lord, my civil suit, I have annexed, my lord.
Page number 52.
Lordship. Yes, my lord. 40. It starts from, my lord, page 43
Your
annexure.
legal notices.
Page 43. Legal notice. Legal notice, my lord, lordship will see 3 legal notice. First one is page 33. Second one is page 36. And final notice was page 39. They did not reply. And they filed a WS also, my lord, which I have brought into record by way of additional affidavit. They had WS, they never made any counterclaim, my lord.
Or did you file your additional affidavit? Okay.
Affidavit, my lord, lordship will see the additional affidavit which I have filed on 13/6/24 at page 89 annexure 1.
Okay. But Mr. Jayar Barhuya, also the petition. And Mr. Jahan and additional but prosecuted everything for the state. Also from Mr. Jayan Udhyapak, Hassan Udhyapak, Learned Counsel for the. Opposite party number two.
Go there.
Inform. Placed on 29th. If you are getting any judgment in the meanwhile, tell us.
Lordship, this is what I'm
You want to
trying
place something?
Yes, my lord, I got two judgment, my lord, I am to rely upon, my lord, and my only prayer is that, my lord, anxiety is that on 21st there is a date, my lord, at least some stay may be granted.
Not to stay till inform the court. Matter is order is reserved to come on. the-
Order is reserved, my lord. Lordship, I like to
Matter
rely
is
to
fixed on
judgment, my lord,
29th.
lordship. Kindly pardon me, I might have marked red, my lord, that part, my lord. Two judgment, my lord, one is the very recent.
Mr. Adhyapak, if you want to furnish anything, you can give it to us by day after tomorrow or by Monday. Monday, Tuesday, wherever you want.
Lordship can only pinpoint, my lord, which I have given judgment, my lord. Lordship will see that elaborate judgment has been given. Lordship will see in case of Ramesh Kumar, para 7 and 8, my lord. That is March 24 of the apex court, my lord. And another one, my lord, I'm not taking time. Another one, which lordship will see the mark as a 3, my lord. That lordship will see operative part of the judgment, my lord. Para 34. And that was delivered on 2nd September 21. Only
Paragraph-
marking point,
paragraph
lordship,
34.
my lord. Para 34. Already I have marked, my lord. Lordship can have a look the marking position. Where there is a civil nature, my lord, or civil case is pending between the parties.
Okay.
Lordship.
Ms. Jahan and Mr. Adhyapak, anything if you want, give it to us by at least by Wednesday next.
No, my lord, judgment reserved, my lord.
Not, we are fixing it for orders on 29th.
Lordship. 21st is the date, my lord. We'll just
the
move
court.
an application.
That has been heard and fixed on 29th. Tell them.
Lordship.
Item number 13.
May I please, my lord? My lord, this is a criminal petition, my lord, praying for setting aside and quashing of the proceedings, my lord, arising out of CR case number, your honor, 725 of 21, my lord. 13. Yes, my lord. On the earlier case, my lord, notice have been issued to respondent number 2, my lord, the private respondent, my lord. They are entered appearance by filing their vakal number today, my lord.
Twelve participants. It is basically like.
Yes. You're appearing.
My lord, respondent number 2, my lord, in this case, my lord, we want to file objection, written objection, my lord.
You want to file objection?
Written objection, my lord, I want to file, my lord. Within 1 week, my lord.
Where is the order of taking cognizance?
My lord, order of taking cognizance 24/8/23.
Hmm?
Page 20, page 44, my lord. 24/8/23. Page 44, my lord. Three witnesses, my lord, including complainant, my lord, were examined, my lord. After that, my lord, prima facie case was made out. That is why cognizance was taken, my lord.
You, Mr.
Vidas, my lord.
For the petitioners. Anonymous Anders Learned Edition of the prosecutor. Status one number 1. So heard. Mr. You, Mr.
S.A. Shikdar, my lord.
S.H. Sikdar. Land Council for the informant. Complainant, that's one number 2. When will you file?
My lord, by next week, my lord.
My lord, there is an interim that may be extended, my lord.
May the circular page for to extend to file. It's affidavit in the matter. Prayer allowed. List up to 2 weeks in a day to be fixed by the registry. Till the next date of listing. The interim order passed earlier on 4/12/2023 shall remain in force.
My lord, there is one more thing, my lord, in paragraph number, my lord, 9, my lord, there is some inadvertent typographical error, my lord. The CR case number that is 725 of 2011, my lord, that has been wrongly typed, my lord, that is 2011, my lord. Similarly, in the prayer portion also, my lord, but in the cost settle, my lord, it was correct, my lord. I may be allowed to, my lord, file a amended-
Appropriate application.
Yes, my lord.
Obliged.
I'm obliged.
My lord, this appeal preferred against the judgment and order passed by the my lord Learned Session Judge Kamrup Amin government. Here the appellant convicted for 8 years. 8 years, no?
8 years.
Under section, my lord, 304B, my lord. And she committed suicide by hanging. 8 PW was examined. Basically, my lord, the father of the deceased, PW2, and PW4 was the mother. On the basis of their statements, the appellant is convicted. So, my lord, the appeal may be admit and LCR will be confirmed.
Mr. Reynolds, counsel appearing for the appellant and MS and thus learned additional prosecutor. For the state. Respondent number 1. By judgment of conviction and sentence dated 17/05/2024. London. Session Judge Kamrup Amin government. In Sessions case number 338/2014. Arising out of Nagarbera Police Station case number 73/2012. Convicted the appellant under section 304B IPC and sentenced him to undergo rigorous imprisonment for 8 years with fine of rupees 20,000 in default to further undergo simple imprisonment for 3 months. Setting off the period of detention already in custody. Already under custody. As per the provision of section 428 of the CRPC. I will be admitted. Hearing. I will be admitted. Call for the records of Sessions case number such and such from the court of learned such and such. As MS and thus learned editions of the prosecutor has accepted notice on behalf of respondent number 1. No formal notice. Cells have requisite extra copies of this memo appeal along with the annexes of NGT. Appellant shall take steps on the respondent number 2 by registered postal date on or before 21st of August, providing his correct and authorities. Steps on the respondent number 2 to usual process through the district magistrate Hamburg. List of 6 weeks. I apply this interrogatory application of the opportunity. Of the appellant for suspension of the sentence passed in the interim judgment in order to 17/5/25 by session judge in sessions case number 7 and allowing the applicant to go on bail during pendency of the connected appeal shall be considered after the receipt of 11 records.
Well, in the meantime, learned people will file the objection. Well.
8 years, not
8 years objection is necessary.
not 10 years is required.
That's 7 years.
Yeah, 10 years.
So it's public procedure. I'll find it public. I read it. Yes,
May I, Lord, please?
yes, Mr. Devi, please.
My lord, there's a three districts are there. Just kindly. My lord, kindly page to page number 62. There are 3 JIBA petitions have been filed.
In fact, Ms. Das was supposed to inform us of the confiscation of the vehicle. Do you have the information with you?
Lordship, kindly fix it on Monday, Lordship. I have not received the instruction till now.
We will have it on Tuesday.
Lordship.
My lord, I'll be have problem. It will be on 27. Because in fact, I'm already sure that there was no confiscation. Report was given.
On 27.
On 27.
On the prayer of Mr. R. Devi, counsel for the petitions. Based on 27. On the sake that Ms. Endas, additional public prosecutor, shall place the relevant instruction as to whether, as been directed earlier on 7/8/2023.
May I please, Your Lordship? Lordship, this criminal revision is basically against the conviction in NI case. My lord, the punishment amount has already been paid by the petitioner to the respondent itself, my lord.
Just a minute.
Lordship is searching for the original judgment, my lord. My lord, huh? Yes. কোনটো আহিব? 7/6/36. My lord, though it was not annexed advertently, but it is in the IA file. It has been supplied on the last occasion, my lord. The IA 636, my lord.
7:31.
7? Sure. Huh? Okay, sir. What did you- Lord, after the judgment, it has been amicably settled and petitioner has paid the whole 8 lakhs rupees to the respondent, my lord.
When?
My lord,
29th of July, 2020.
yes. We have the receipt, my lord. May I submit to the? Check from the 30, just like it already paid for as it is.
You have entered afferent for the respondent number 2.
Yes, Lordship.
When did you file occurrence number?
Lordship, in the last occasion, when the IA 636 came up in the court. Most probably it was on 5th of August, Lordship.
Criminal 636. Equivalent.
Pilot नहीं? क्यों? No pilot क्यों नहीं?
Any note class based last total
No, single days or not? Single days. The single days when I. That's one into the. Oh. Tapi kan bahas ni, tu kau tadi tu kan, tadi mana sih? Kita ni kau tu, kami jual apa? Kami jual apa?
What's your good name?
S. Yasmin.
Some DMAD has filed it. Only one name has been shown. That's why we're in search of your Wakalatnama.
Lordship, D. Mehdi is also my colleague. We both of us have put our signature in the Wakalatnama.
But the Wakalatnama is not available here.
Kone file kora boleche?
Respondent to কথা আছে ICSP নাম আছে
So DMAD will be coming on.
Sure. Okay, yes. My lord, as I have been told that in interlocutory application 636, there is a office note reflecting her name itself, my lord.
Okay, it's fine. There is a official. Yes, what do you have to say? You have received the amount. Entire
I
amount you
have
have
received
received.
the money. Lordship, I have received the entire money of rupees 8 lakhs rupees. Rest I leave it to your lordship. I have no objection if any relief is granted to the petitioner side.
Third, Mr. K. Thakur. Counsel ready for this petitioner. And MS. Cables. Learned. Additional public prosecutor appearing for the state respondent number 1. Also heard MS. S. Yasmin, counsel for the respondent number 2. In a proceeding under section 138 of the NI Act, the Honorable Judicial Magistrate First Class Board in NI, in case number NI 216/2022, convicted the petitioner under section 128 the NI Act and sentenced him to undergo simple imprisonment for a period of 6 months.
My lord, I'm sorry, my lord, I'm leaving, my lord, he will be here.
And further, directing him to pay compensation of rupees 8 lakh to the complainant. I, the respondent to the comma, in default payment of fine to undergo SI for further period of 2 months. You agree with this sentence and order dated Friday, 14/7/2023 of Ladat JMFC Corporator. The petitioner preferred an appeal. Before the Ladat Session Judge, Corporator, being criminal appeal number 27 of the 2023. Ladat Additional Session Judge, being vacated Corporator by judgment dated 18/12/2023. Dismissed the said appeal of the petitioner. Criminal appeal number such and such preferred by the petitioner. Uphold the order that 14/07/2023. Passed by Ladat JMFC Corporator. In an case number such and such. And directed the petitioner to deposit the compensation amount within 13 days to be complainant as testimony number 2 and to surrender before the Ladat Court of JMFC Corporator to serve the sentence within a period of 30 days. Agreed. Receipt. Judgment of Ladat Additional Session Judge. First instance. The petitioner preferred this revision petition. Do by orders 18/12/2023, the London Appellate Court dismissed the criminal appeal case number 27 of the 2023 preferred by the petitioner, directing him to surrender before the London JMFC court letter and receive NI case number such and such within 30 days. But he did not surrender. And as such, the London JMFC Barpeta by order the 01/03/2024 passed in sake NI case number such and such issued non-bailable warrant of arrest against the petitioner / convict. What happened on 16th July? What happened on 16th July? The last date was 16th July. What happened?
16 July, the subsequent order was passed, Lordship, for NBWA. Thereafter, Lordship, when we get the allowed the condemnation of delay petition by this honorable court, subsequently we went to the court and communicate the order, and thereafter the warrant issued by the Lanet JMFC was recalled, and as per the order of this honorable court on the petitioner is to appear before the JMFC on 19/8, Lordship, 19/8/2024, Lordship. The warrant is already recalled, Lordship. In II Criminal 636.
It is submitted by the petitioner after the order of the court that 582024 passed in I within brackets criminal number 636 of the 2024. The order of NBWA issued by the line of JMFC in such and such, and I case number 216 of the 2020 was recalled. And the next date of appearance of the petitioner is fixed on 19/08/2024. It is placed by the petition that in the meanwhile Because the amount of compensation of rupees 8 lakh. He has paid amount of rupees 5 lakh in cash. And rupees 3 lakh. To check. Quite number 000004 dated 30/02/2024. Drawn on HDFC Bank, HDFC Corporate Branch. And paid it to the respondent number 2 complainant on 29/07/2024. Which the respondent number 2 duly received on 29/07/2024. To that extent, MS Yasmin, learned counsel appearing for the respondent number 2. Have also accepted the same. It is further stated by the petitioner that the said check amount of rupees 3 lakh that is 30/08/2024 noted deposited paid to the respondent number 1. Sorry, respondent number 2 was instructed by the wife of the petitioner who had given an undertaking that if
I'm sorry, Lordship. May I please, Lordship? Lordship, it was an undertaking was given, but today itself, Lordship, entire amount is clear, Lordship. Today is
sure.
Yes, Lordship.
That if the said amount to the stake amount could not be paid, then she will be liable to pay rupees 3 lakhs in cash on 30/08/2024 to the respondent number 1 complainant. However, both counsel for the petitioner, Mr. Thakur and Ms. Yasmin Lanet, counsel for the complainant respondent number 2 submitted. Cash or in check, check amount has been cleared. Check amount cannot be cleared because it is of 30th of August.
Lordship, in case today.
Submit that the respondent number 2 received the cash amount of rupees 3 lakh from the petition in lieu of the check number such and such already, direct such and such. Drawn on HDFC Bank, corporate branch, issued by include us wipe off. That made this revision to be. IIT होती है मिलेंगे रोड हमारे को ना such and such no formal letter. Go to the honor. Yes, no formal letters. Petitioner sells requisite extra copies of this revision petition along with the annexes appended to such and such. To Ms. Zahan and Ms. Sisson on or before 20 of the minister. Until further order of the impugned radical additional session does work better. Serving and suspended. However, the petitioner shall appear before the court of London or the West December, Mrs. and I case number 7 on 19/08/2024 as ordered earlier by the site magistrate. We appear on 19th.
I dispose of lordship.
Highly obliged.
In item number 15, if
One
your
thing.
lordship, in item number 15, lordship has ordered us, directed us to get the instruction as to whether confiscation proceeding.
Only
I think as per law, confiscation cannot start before conclusion of the trial.
there is another order.
That I have seen, that it is already.
In another case recently we have seen
Acha.
that confiscation has been when the trial is going on.
Otherwise, statute.
Normally
provides-
conclusion, but
Ah.
whether it has been sent for confiscation because there is another order is passed. That is why I was just little surprised. So just get the information. Otherwise, without the vehicle could not have been confiscated in the other case I'm talking.
Yes.
But a trial is going on.
That of course cannot be, of course, one proviso is there that not before 1 month from the date of seizure. Now, trial cannot be over within 1 month.
Let's find out.
Lordship.
Also get the report from the concerned IO. By those vehicles.
High Court judgments I have only on conclusion of the trial. Supreme Court judgment, of course, I have to yet find out. On the next date, Lordship, I'll
Get
get
the
those.
very- Let us see.
Let those judgments.
Yes.
Lordship, in this case, opposite party has filed an affidavit in opposition just at 2 p.m. Lordship. I have received it and I have to file reply against that Lordship. Against the distress warrant, we have filed this criminal petition Lordship.
There's an interim order, I believe.
Yes, Lordship.
RMS MD and counsel appearing for the petitioner. And MS and us, learned additional public prosecutor. For the state respondent number 1. Also heard Mr. Dr. Andika, right? Correct. Learned counsel for the respondent number 2. It is submitted that the respondent number 2 has filed an objection today. Copy of which has been served on Ms. Dev in the afternoon, this afternoon. And Ms. Dev is saying some time, praying for some time to go to the same. Prayer allowed. List on, yes, Ms. Dev, tell us.
September, any day.
3rd September also.
3rd is a Tuesday, not have it.
Can be on 5th Lordship.
6th. 6th of September. Till the interim order passed on 26/06/2024, shall remain in force. The court registry shall incorporate the affidavit filed by the respondent number 2 in the case record.
Interim order recently.
Lots. Oh, 6. Lots.
Alright.
Good one.
My lord, in this case, when a report was called for, my lord.
Lordship, of course, a written report is not there, but I spoke with the Hualkusi OC. He said that he has completed investigation as far as the mobile phones and the bicycle is concerned. So he has no objection in giving a
Get a written report.
written report, Lordship. I'll get it by tomorrow, then she will fix it up. 20 seconds,
We'll have it on 27th.
27th,
By
Lordship,
that time you have the written report.
written report, Lordship.
Heard Mr. S.S. Raman and counsel appearing for the petitioner. And Ms. as Zahan, additional public prosecutor for the state. Though Ms. Zahan, additional public prosecutor has obtained verbal instruction, but she is yet to receive the written report from the concerned investigating officer of Swalpuri CPS case number 169/2023. List on 27th, enabling Ms. Zahan to place the necessary report from the concerned investigating officer of Swalpuri CPS number.
Lordship.
Right.
To do signing the fixed for
We got the instruction, FR, there is a final report.
when
Final report on 24th of August 23. Report number is also there. So first one is final report, second one charge sheet.
number
Number 1496. 1496 of 23.
dated
Dated 24/08/23.
or Mr. Adas. Counsel appearing for the petitioner. And MSS Jahan Lal, additional public prosecutor appearing for the state. The petitioner is an advocate, is a practicing lawyer. And by this application and by filing the connected criminal petition 110/2020. She prayed for quashing of the FIR dated 20/07/2016. Lost by the opposite party number 2. Being Jalukbari Police Station case number 585/2016. Under section 406/420. Corresponding to GR number 8143/2016. Wherein the police, after investigating the matter, submitted the search sheet file number 168 dated 31/07/2016. And when the cognizance was taken, Mr. Das,
Cognizance order লৈছে? Cognizance order কেতিয়া লৈছে? Cognizance কেতিয়া হৈছে? এইটো 68 নেকি? Page number 68? Yeah, Lordship will see page number 68. Oh, no, this is,
not on 60.
no, this is summons to an accused person. No. নাই লগোৱা নেকি? Cognizance order কেতিয়া ললা? Cognizance আছে কোর্টে?
We have received summon,
Yes.
but when cognizance was taken,
Hello, someone?
we have seen the summon.
Page 68 এর আছে। কাগজটো পিছুৱা। নাই কৰা। He has not annexed in a cognizance order.
Annexed D, my lord, in IA petition, 3523.
Actually, yes, there is an IA there. Their orders were annexed. 9/11/22.
But not okay. On P5/24, I have received. From 9/11/22, continuously someone is recorded, but I have received P5/24, my lordship.
My lord, kindly see, in cumulative petition, my lord. Para 10, page 11, my lord. My
Yes,
lord,
we have seen, Mr. Das. You don't have anything in your record. After filing of the said search sheet, Jalukbari PS case number 585/2016. Learned Additional Chief Judicial Magistrate, Kamrup Metro, Guwahati. on 4/11/2016 to cognizance of the offense under section 406/420 IPC against the petitioner. It says here case number 8143/2016. The court, while issuing notice on 07/02/2020, the connected criminal petition 110/2020 call for scanned copies of the said GR case number 8145/2016. Eight one. This is not 8145, 8143. However, the court on 7/2/2020 did not state or did not pass any order relating to the interim pair of the petition. Hence, this application by the applicant petitioner for stay of the proceeding of the said GR case number such and such pending before the Court of Learned Additional CJM Kamrup Metro Guwahati. Petitioner contended to the applicant that she earlier filed a criminal petition. Filed. An affair before the Jalukbari police station on (15/07/2016) against the opposite party number 2 / respondent number 2 and another which was registered as Jalukbari Police Station Case Number 572/2016 under Section 294/406/420 IPC. Corresponding to GR number 7959/2016. And that the mutilation of the same in the opposite party number 2, respondent number 2, filed in the affair on 19/07/2016 with certain allegations against the applicant petitioner that was registered as Jalukbari Police Station Case Number 158/2016. One 589, 585. (585/2016). Though in her criminal petition, in her and though in the said Jalukbari PS Case Number 572/2016 registered on the basis of affair lost by her, police did not inquire into the matter. Neither filed any search sheet nor filed any final report. She preferred a criminal petition being, she preferred a criminal petition being criminal petition number 1513/2019. Praying for a direction to the authorities concerned in the directing the Jalukbari Police Station to take necessary action in respect of said Jalukbari PS Case Number 572/2016. Wherein notice was issued way back on 03/01/2020. Wherein the present opposite party number 2/session number 2. So also party respondent number, opposite party number 2. On being inquired, Ms. Zahan Lal, additional public prosecutor submitted on instruction submitted that during pendency of this of the criminal petition number 1513/2019, Jalukbari PS submitted the final report against the present opposite party number 2. No, don't direct. So for final report liquidation, file number 1496/2023. The date 24/08/2023. Full stop. Peruse the records of GR Case Number 8143/2016. Have you gone through the records? Go through
Yes,
and tell us on the next date.
Lordship. Documents that they have annexed have gone through, but not the LCR.
Go to it.
Yes.
Miss Jahan Lal, additional public prosecutor, is allowed to go to the records website, GR case number 8143/2016. List on. Ninth of September. On the same date. Both the state as well as the response number 2 / opposite party number. But the parties shall make the necessary submission. Until further order of the court. The proceeding of GR case number 8143/2016 pending before the Court of Learned Relationship Judicial Magistrate Kamruk Metro Guwahati shall remain suspended.
That's
Mr. According. Which Mariba? (22) dispose of. In view of the submission made by MS Jahan Lal, additional public prosecutor,
he's there for, he's a.
that the police, after necessary investigation, submitted the final report in Jalukbari Police Station case number 572/2016. File number 1496/2023, dated 24/08/2023. This criminal petition being in flux was stands dismissed. Hard Mr. Redas for the petitioner. MS as Jahan additional public prosecution for the opposite party number 1 and Mr. T. Sarkar, learned counsel for the opposite party number 2 to dispose of 23 1513.
9th of September.
আৰু বাকি কেইটা একেলগে You return it to us, we go through the record. Next.
For bail hearing, item number 19.
Alarm.
May please your lordship. Last occasion, lordship, scan copy of the case record was called for, lordship, in this case.
Scan copy recent.
You got it?
Yes, sir.
You have gone through.
Yes, Lordship.
Tell us.
Lordship, PW2 Lordship. In his statement, he proposed that Lordship, from them, Lordship, from 2 cars, Lordship, the materials seized. He was there, and Lordship statement of PW4 also, Lordship. So materials are there, Lordship.
You declared hostile, lordship.
Let us.
PW1 also, Lordship, and they have, Lordship, deposed that 663.96 gram heroin recovered, Lordship. So these are corroborated, Lordship.
PW1,
Yes, Lordship.
PW1, PW3.
PW4, yes, Lordship. PW4 is the informant, Lordship.
1, then
3 and 4, Lordship.
May I submit, Lordship?
Yes, ma'am.
Lordship, what happened in this case, Lordship, petition number 1 and 2 are brother and sister, Lordship, and they were arrested on 24/7/2022, more than 2 years, Lordship. What happened on last month, Lordship, on March, 12 March, Lordship, the family of the petitioners were meet an accident, Lordship, and due to that accident, Lordship, mother and brother of the petitioner number 1 and 2 expired, and father is still undergoing treatment, Lordship. And one minor child of the petitioner number 2, she is alone, Lordship. No one is to look after her, Lordship. Accordingly, we have filed one application before the learned trial court, and learned trial court rejected that application. That gravity of the offense, bail petition was rejected, Lordship. So due to long detention, Lordship, the child is suffering, Lordship. She is only 3 years, Lordship. I have annexed her birth certificate also, Lordship, along with this application. And Lordship, death certificate of mother and father is also annexed along with the application, Lordship. So there is a lot, due to long delay, Lordship, in fact, their right to defense is also suffered, Lordship. In fact, Lordship, all this aspect is covered by one recent judgment passed by the Honorable Apex Court in the month of July, Lordship. May I place that judgment, Lordship? Particularly, Lordship, paragraph 23, 23A and 32, Lordship. Here petitioner is a or resident from Nepal, Lordship, in that case, Lordship. 23, 23, 1 and 32. Till date, Lordship, 4 witnesses are examined, Lordship. Out of that, Lordship, 1, 2, 3 are the seizure witness. 2 and 3 declared hostile, Lordship. And regarding one, Lordship, cross part, that is not support the prosecution story, Lordship, entirely, Lordship. Cross of PW1. And 4 is the informant. What's the name?
Miss Bachchanji. Your prayer is that the lady's mother and brother expired,
Yes, Lordship.
and she has a minor child,
Yes,
and there is none to
yes,
look after. And her father is also sustained injuries in the accident
yes, Lordship.
and now is under treatment. That's your submission, right?
Yes, Lordship.
Now, please come to page number 42. Name of the patient. Name of the patient.
Yes, Lordship.
What is it? P. Jonathan,
Yes, Lordship.
resident of Saranmai Kaiko,
Yes.
page number 43. P. Jonathan,
Yes.
resident of Saranmai Kaiko. It is of 15th of June 2024. The
Yes,
previous one was 14th of March. Then page 44. P. Jonathan, this time it is Christian Colony. That is of 23rd of July 2024. Then please come to page 45. P. Jonathan,
Yes.
Christian Colony. Page 46, P. Jonathan, Christian Colony. That is of 24th of July. Again, page 47, P. Jonathan, Christian Colony, 24th of July. Page 48, P. Jonathan. You claim that he is your father.
Father of the petition number 1 and 2.
1 and 2.
Yes.
Right, absolutely correct. Now, come to page number 20. See the name of the father of the both brothers and sisters.
Mohan Salcham.
See
Jonathan.
the address.
Address of the petitioner, Lordship, then names Jonathan Salcharmal. And there is P. Jonathan.
What do you have to say?
Whether both are same person or not.
Be very careful. Reject. And
Otherwise,
this
the
application has been filed by the sister. So she
yes,
can
they
take
filed
care of, they can, if you come to the affidavit page 13.
Yes, yes, yes. Lordship. That is six by file by, and that is by sister. Lordship.
Here, look at the name and whose daughter.
Jonathan Salcham.
Yes.
Rejected.
Also regarding Lordship, Article 21 also I have.
For that reason, only reject it. If you insist.
Like,
Non-appearance Lordship. Not silent.
Yes, Ms. Jahan, appeal against acquittal, no representation, nothing for last 3 occasions. Steps not taken since 2012.
But appeal lordship cannot
That's
dismiss
the
on default.
thing. Can we maintain it like this?
Lordship can appoint an amicus.
For whom?
Oh,
For whom?
for the informant. Again, notices will go to the accused.
So tell us if this is the conduct.
Hmm.
This is the 3rd occasion they did not appear. And since
okay.
2012 did not take steps on the to take on the accused, the acquitted accused.
I'll see whether appeal against acquittal can be dismissed, but appeal as such cannot be dismissed on default.
Definitely not. The thing is this, how to adjudicate this matter? First of all, the appellant is represented by a set of lawyers, did not take steps since 2012. There are others. Record is here.
Let the registry send a notice to the informant. That counsels are not appearing. Yes, KK Bhuya, I know him, KK Bhuya. What's KK Bhuya?
No point. The last order.
Here is a say. The appeal cannot be dismissed for default. What is it?
No representation on behalf of the appellant on call. The name of 4 counsels have been reflected in the cause list. RMS Jahan Lal, Additional Public Prosecutor for the state. This appeal is against by the this appeal against the order of acquittal passed by Learned Judicial Magistrate First Class Kamrup Guwahati in CR case number CR3 in case number CR 3030 উপরোক্ত লিখে oblique 2010. Dated 01/08/2012. Whereby the respondent number 1 was acquitted. Initial case preferred by the appellant as a complainant, acquitted the respondent number 1 from the charge of section 138 of the NI Act 25. It is seen that on consecutively in the last 2 occasions, I on 17/7/2024 and 05/03/2024, the appellant and earlier on 23/12/2021. Out of the last 4 occasions. Matter listed before the court. I on 17/7/2024, 05/2024, and 23/12/2024 remain unrepresented.
Your person? Doesn't keep it. Fine and why?
Registry shall issue the notice to the appellant complainant Sanjay Das, son of Sorodhan Das, resident of BR Pukon Road, Moscow. Police, post office and police station, Paralamu, Guwahati 781009, District Kamrup Metro Assam. Regarding the pendency of his disappeal since 2012.
No, it took against conviction.
List after 6 weeks.
Is paragraph six is conviction.
Authorize.
Lordship, I beg to mention item number 41, Lordship.
Hmm.
So this matter may come up next week, Lordship, any date, Lordship. This is 389 petition, Lordship, from on last 10 occasions, matter was listed but could not reach, Lordship. Some urgency is there.
You
If we had
should
the power.
mention in the morning, we have been upgrading so many cases.
Yes, Lordship.
Why you have not mentioned?
Next,
Mr.
next week,
Sarkar?
Lordship, any day.
Next week it will be difficult,
On Thursday, Lordship.
29th.
Wait, please. Lordship, regarding item number 35, Lordship, only LCR was called for a fresh reminder will be given, Lordship, several dates, Lordship. It was not come, Lordship, we have 35, Lordship.
Okay, you are keeping in. Okay.
High level.